Good morning. It's Tuesday. It's time for coffee and Cursey words. It's officially fall, not on the calendar, but it's Starbucks, and my basic butt is really happy about it. Yes, I'm sitting here for coffee and Cursey words with a glorious pumpkin cream cold brew. Look, I don't care that it's August. It wasn't 90 when I woke up this morning. I can classify that as the air feeling crisp, kind of. Sort of cool, not really, but I'm faking it. I'm faking it. It's why there are cold brews in the pumpkin because, it's fakey fall, but we're going to enjoy fakey fall until it's real fall. So let's just enjoy it. We've got a lot to talk about today. I had put this up for our top two tiers on Patreon, and today we're really covering what the law nerds voted on. We've got new minute orders coming out of the Britney Spears case. We've got a lot going on with the Chrisley convictions and the civil lawsuit. Yes, we'll talk about it a little bit. And then we've got a quick bit for you regarding the Newman's own lawsuit. We're going to take a look at the reporting on that and see if we need to pull that lawsuit and deep dive into it, which is really what we use the quick bits for. It's so we can take a look and see if we need to go a little bit deeper into it. And then I have started seeing rumblings that the BitBoy crypto lawsuit with a Tuesday might be resolving. So I will pull that and update you about that on social media because this is my only live stream this week. I know. I have to keep you guys updated. We're at the beginning of travel craziness for me in September. So I will keep you posted on all of the socials about the schedule. I should be here most Tuesdays. Thursdays are going to get a little hit or miss, but I will keep you posted. The podcast will go up every Wednesday at 11. I will be in the chat, even if I'm on a plane with that, the best that I can. And I will, again, keep you posted on social. So already we're starting like that on social. We should get going. I'm going to roll the intro. It's so good to see everyone coming in. Let me know where you're watching from, and I will see you. Well, I'll see you after the intro. Let's just go. We should just get started. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. You guys are coming in with all kinds of fun stuff today from all over the world, and it is so fun to see you. Hunter asked, have I heard about Rockstar Cheerleading in Greenville, South Carolina? No, I haven't heard that. And for those of you asking about the intro music, I normally let the replay crew particularly know what's going on. Replay crew, we love you before we go into the intro. Why? Because YouTube tells me I have to. Sometimes I abide. Sometimes I do not abide by the things that YouTube is like, we really prefer it if you tell people what you're doing. Look, there's rules, and I had the audacity to be sick for a little bit and take time off. YouTube's like, we don't know her. So I'm trying to abide by the rules. We would like to eventually get back to y'all getting notified when I go live. That would be fantastic. So replay crew, love you. There will be timestamps down below. We're going to get into quick bits, and then we're going to go. We've got a lot of motions to go through. We've got like 6-minute orders to go through, and then we're going to do a little chitty chat. So for all of you who said thank you for the coffee, y'all follow me on Instagram. So for those of you who don't follow me on Instagram, this morning we did a Starbucks card so y'all could treat yourself. Why? Because the prices at Starbucks have had a moment for themselves. I don't know what the price of cold brew is, but every single time I go to Starbucks, I feel like it goes up. That's, across the board, isn't it? It's just life is getting more expensive. Like I'm like, oh, this has been my regular order for a while. And that's not the price I normally pay for it. And I know that so many of you are feeling it too. So I wanted to share a little joy this morning and throw up a cold brew or two. I reloaded it numerous times. I will do it again soon. and let y'all grab a coffee. So I did that this morning on the way to Starbucks. I appreciate it. Lauren Sawyer said, first super chat, coffee and Cursey words on my birthday. Cannot get any better. I'm sorry. I should have warned those of you that had pets. I apologize. I will try to remember to do that. I get it. The soundboard makes me excited.
Happy birthday, Lauren. I can't stop.
Can you imagine? We're going to have to do a transcript reading for the members. And this is going to have to be Viv's voice.
Oh my God, Your Honor, a stranger. You want to appoint a stranger.
I'm going to have to do it. Hello, Catherine. Good morning. Hello, Nadia. Thanks for the coffee. You're welcome. I know some of you got them and tagged me. It was so fun to see what y'all were ordering. Hello, Elizabeth. Thank you for the super chat. Rudy said pumpkin spice is a starter drug. It is a starter drug. Pumpkin spice is the intro to basic. You get your Ugg boots, you get your messy bun after that. Then you start eating like pumpkin pie for breakfast, like a complete degenerate. I'm just kidding. Pumpkin pie for breakfast is the greatest. And I love it. So with that, I've been wearing Ugg boots since before they were cool, when everybody used to make fun of me because they're like, what are those ugly boots? I'm like, they're Ugg boots. They're like, they call them that because they're ugly. But when I was, a tween getting out of swim practice at night and it was freezing. Yes, it gets cold at night in California, and especially when you're wet. They were the only things that kept my footsies warm after swimming, after being at the beach surfing and things like that. So I've worn Uggs forever. When I went to UMass Amherst and brought my Uggs with me, people were like, seriously, what the fuck are those? And so the Ugg boots have been a thing for me since, I don't know, the late 80s, early 90s. And then the folks in Massachusetts were accurate when I believed my Ugg boots to be winter boots because they were my California winter boots. California winter boots are not winter boots in places where there's ice. Because the Ugg boots with the very slick bottom, great for walking on sand or a pool deck, awful for walking on ice. I think it's the beginning of my back injuries. I think the beginning of the end was me slipping on ice at like 5:30 in the morning, walking to water polo practice in Ugg boots like a moron. There were like 3 dudes carrying lacrosse sticks. They're like, what? And I was like, I need new shoes. And then it's not like, I don't know, do college kids today, I'm sure some of you have college kids. Do college kids today just go on like Amazon and Zappos and like get the shit they need at school? Because I was like calling my mom being like, I need a backpack that the zipper won't freeze shut on and a jacket. My mom was like, I think my mom mailed me like an LL Bean catalog and was like, pick a few things, we'll have them sent to your dorm. Life today is so easy. None of us had a car. Now you're just like, deliver it. When I did my TED Talk, after that, I was at Cal State Long Beach and they had the giant banks of Amazon lockers. I'm like, brilliant. Of course they do. Of course they do. All you have to do is Amazon it. Everything just shows up. I don't know, man. Kids today, you guys, look, life is easier for you. Life is also harder for you because you go to college at an age where everyone can document everything you do. And God knows there are things I did in college that should never, ever see the light of day. And all of us that went to college in the 90s have this understanding that like, we don't talk about what happened in the 90s. We know. But no, there's no photo evidence. There's no video evidence. And if somebody was trying to be shady at a party and take a picture of what was going down, there was a flash on that bitch and you knew exactly what they were doing and who it was, and you could take their camera from them and expose the film or not. But now you don't even know. Look, things come to you easier. You can get things delivered. But I think with social media, life is still a little harder. I didn't know that backpack zippers would freeze. I didn't know that was a thing. And again, I did not know nearly enough when I just was like, willy-nilly, let's move to Massachusetts in college. Let's just go. It'll be great. But I had a very, very beloved field jacket that got very muddy at like a Hobart hoedown and had mud on it for years. It just was muddy. It was like, my mom's like, I'm not replacing your jacket. I don't know what you were doing. I'm like, I don't know what I was doing either. Anyway, we don't need to talk about college in the 90s, a different experience, I'm sure, than today. Y'all, well, things are easier. I think things are also a little bit harder. No one from my job would have known what I was up to at college because there wasn't evidence of it anywhere, which is funny when you see the teenage dirtbag trend across like social media and people are like, I don't have all my teenage dirtbag photos. We weren't all just taking pictures all the time. It's true. It's true. all of you UMass people know exactly what I'm talking about. Never did I ever get arrested. Why? Because I'm very convincing. Am I the person you want to be with if the police show up? Yes. Why? Because I can generally de-escalate a situation, for sure. Might have done it at a house party or two as an adult as well. It was like, what's going on here? It's like, it's the end of the year parents party for the PTA. They're like, the neighbors are complaining about the noise. I'm like, yeah, but the noise ordinance doesn't say, it's not quite. Can you guys give us like 15 minutes? I promise we'll wrap it up. Okay. So with that, we should get into what we're talking about today. The first thing we are talking about, here's the secret at a party. If you can, try to be understanding, not belligerent, and start with, how can we help you? And then try to go from there. It doesn't always work, but it's a good starting place. How can we help you? And then try. If you have that one friend who is out of control, be like, I promise we'll take care of it right now. Thank you. We've got it. We've got it. We've got it. All right. Let's talk about, speaking of things that are out of control, let's talk about what's going on with Paul Newman's daughters suing his charitable foundation. And we need to see if we need to do a deep dive into this. So with this, we should get to quick bits. Quick bits. Look, it's like I'm prepared today. Whop. We are, in fact, professionals here, people. Eventually, we're gonna stream like a pro. No, we've got it. We've got it. Also, I should remind you to do the YouTube things. I'm told that it helps and it actually matters. So, do the likey, subscribey things. So, anyway. We did, I will tell PTA party stories at some point. We did have PTA parties on occasion. It was a fun way to get to know people, which was great. So let us continue into this. I didn't know this was going on. A number of you tagged me when this story broke. We didn't have a chance to get to it last week, so I was pulling it up today. Let's see. So 2 of the daughters claim Newman's own foundation has lost its way, taking issue with the nonprofit for having the amount of money directed to them for their own charitable giving. So based on, we're going to get into it, but based on this headline, it sounds like the daughters say the foundation has lost its way. So because the nonprofit is not giving as much money to the daughters who direct it to their own charitable giving. And that's a really interesting thing. So a lawsuit exposing a rift between 2 of Paul Newman's daughters. I have no idea how many children Paul Newman has. Chat, if you know, let me know. I need to know. I don't know. A lawsuit exposing a rift between 2 of Paul Newman's daughters and the late actor's Charitable Foundation alleges its leaders are betraying Newman's directive for his family to be intimately involved in the organization. They allege that the Newman's own foundation improperly cut the mandated is a strong word, because if it's mandated, it's probably written down in there, in the directives, if you will. I always feel like I'm in the movie Wall-E when I say it. Do I need to do it? Yeah. Directive. I can't help myself. But if it's in the directives, it feels like this is probably written down somewhere. 6 kids. Okay. Everybody's like 6 kids. So that'll be interesting to hear what the other kids have to say if only 2 are suing. So directives should be written down, should be easy to determine what was directed. They allege that the Newman's Own Foundation improperly cut the mandated. So now we have directives and mandated. Oh, I hope this is attached to the lawsuit. Okay, we might have to do another dive into this to see if it's attached. Cut the mandated contributions to entities controlled by his daughters, Susan Kendall Newman and Nell Newman, from 400,000 to 200,000 annually. What will be interesting is if the amount, and this is me, this is how I read through things in my brain. I'm just doing it out loud with y'all. What will be interesting? I have fuzz. I think the fuzz is on the microphone. My cats. Any of you that were on the behind the scenes podcast reporting, no, we were struggling with fuzz last night as well. But with that, if they're supposed to get a percentage of charitable contributions versus an amount, that would be different. Because if it's a percentage, I can understand that maybe over the last few years, world events have reduced the amount of money going into the charity in the first place, so that might be, look, 10% of whatever it is, or this is numbers I am pulling as example, 10% or 15% or 20% of whatever could have gone down. A 50% decrease seems like a lot, but it'll be interesting to see what the mandated contributions are, and if the mandated contribution was set at a dollar amount or set at a percentage. So according to the lawsuit filed Tuesday, and again, this was published on August 24th, so last week, in Connecticut State Court, they claim the first step toward completely ousting their family from the foundation funded by profits from their father's publicity rights. And that includes things like salad dressing and other publicity rights. And we see, a lot of charitable celebrities giving their likeness rights and all of their likeness rights going to charity. When I was, we went to an event here in Nashville at the Gibson Garage, and the lead guitarist from Rush had done a collaboration guitar with Gibson, and all of his licensing and likeness rights, and that was all, instead of being paid to him, was being paid from Gibson into the Gibson Gives charity. So this is not uncommon that this is done, but let's go on and see what the complaint says. And again, lawsuits are allegations written in the light most favorable to the party writing them. Beck's saucy is appropriate. Saucy is appropriate. Saucy is appropriate. Touche. Well played. Newman's own foundation lost its way and strayed from its mission to preserve and honor Paul Newman's legacy, states the complaint. The years since Mr. Newman's death consist of a long and consistent pattern of disregard by those in control of Mr. Newman's specific intentions and direction, coupled with mismanagement, scandal, and questionable practices. Scandal? I have questions. What is the salad dressing scandal? Scandal at a charity. Oh boy. The Academy Award-winning actor and director created Newman's Own Foundation in 2005. The nonprofit controls and is funded by food and beverage company Newman's Own, which uses the actor's name and likeness to sell salad dressing, pasta sauce, and other products. The foundation reported $24.6 million in revenue in 2020, according to tax filings. Okay, so depending on what their regular revenue is, it's not, $24.6 million in revenue is still a lot of revenue. Under the agreement, the daughters claimed that their father conditioned the agreement. Oh, keep reading, Emily. Conditioned the agreement on their involvement in the foundation. They seek $1.6 million in damages to be donated to charities of their choice, and an order forcing the foundation to follow Newman's wishes. This has to be written somewhere. The foundation said in a statement that the board's philanthropic decisions vary each year and that it needs to make the best use of its finite resources. Quote, best practices surrounding philanthropic organizations do not allow for the establishment of perpetual funding allotments for anyone, including Nell and Susan Newman, the statement concluded. So the foundation's fighting back. Quote, a meritless lawsuit based on this faulty wish would only divert money away from those who benefit from Paul Newman's generosity, while we expect to continue to solicit Newman family recommendations for worthy organizations. Our funding decisions are made each year and will continue to reflect the clear aim of Paul Newman and our responsibility to the best practices governing private foundations. Oh, the daughters aren't members of the foundation's board. Interesting. There's more here. When creating the foundation, Newman laid out specific plans in its structure in a living trust. Well, if there are specific plans, then there are specific plans. A 2005 document he shared with his advisors and daughters detailed that Newman's Own would pay royalties to its parent company for the use of his name and image rights, according to the complaint. The foundation would in turn distribute funds to his daughters' foundations for them to donate to charities of their choosing. Okay. There's nothing wrong with saying, okay, this is going to these other, we're donating to a main foundation, and then we're donating to these other entities controlled by the daughters. That's not, that's not wild unless it's not what's written. But the lawsuit claimed Robert Forster, Newman's former advisor, who ultimately became CEO of Newman's Own and president of the foundation, and Brian Murphy, Newman's longtime business manager, manipulated the actor when his mental capacity was declining into appointing them to the board in his will. Oh, boy. It had been clear for some time that Mr. Newman was unable to act as trustee of the living trust, states the complaint, which is embedded below. Okay. We're going to have to do a deep dive. We have to read it, not today, but we have to read it. We just have to go through the living trust if it's included in the lawsuit or in the article. I'm going to link this too, so you guys all have it. I love when the Hollywood Reporter includes these things in here. So I'm going to include this in the chat, and then I will also, for the replay crew, put it down below in the description so you can go take a look on your own as well. This is why I hesitate to even call them quick bits anymore, because then I get fascinated and I'm like, oh, wait, there's more. This is. Okay. We're going to continue. So it has been clear for some time Mr. Newman was unable to act as the trustee of the living trust, states the complaint, which is below, rather than advise Mr. Newman's daughters of their right to and their father's unequivocal direction that they should appoint a co-trustee to act with Forster and Murphy. Forster and Murphy instead unilaterally seized control of Mr. Newman's affairs. Oh, weird. Someone taking advantage of somebody who's wealthy and elderly. Shock Pikachu face. As to NOF and as to his planning decisions. Newman's family was, quote unquote, shocked when his will was read to them because it strayed so far from what they had been told leading up to the actor's death. What I will say, though, is that there are times when people manipulate wills at the end of someone's life, and there are times when people placate their families and tell them one thing, and then the will is completely different because they didn't want to deal with their family. I'm not suggesting that is the situation here. It's just very interesting. Oh, it's really interesting to see this play out. This reads almost like a wills and trusts exam at this point, because this circumstance is so unfortunately common. Dealing with wills and trusts is difficult. Dealing with money after somebody passes is difficult. Sometimes this happens within families with siblings. Look, y'all, talk to your siblings, know their spouses. This shit can get really difficult. Just hashtag not legal advice, but also. They were threatened with disinheritance if they contested it. And that is common. That is not always allowed in every state, but that is common, that it's like, if you contest the will, you're cut out of the will. I'm getting flashbacks to wills and trusts. Well, it points to Newman's living trust, which is an area of law that when I took wills and trusts in law school, I was like, nope, immediately, nope. Immediately, nope. Well, it points to Newman's living trust. The complaint doesn't cite the foundation's governing documents. Oh, boy. Here's the thing. If the will was changed, well, it depends when it was written, or if the living trust was changed, and they are now trying to undo that, because here's what I'm wondering before we get all the way down. This is what the brain is wondering. If what they're alleging is true, and these two individuals overtook, Paul Newman's will, changed his living trust, and then became the heads of the foundation and the CEOs of the company, then they would have been the ones writing the document for the charity. So the ones who are in charge of writing the document for the charity might have written the documents so that it didn't absolutely give the rights to the daughters, which is why they're looking at going all the way back to the living will and or to the living trust documents, not living will. I mean living trust when I'm saying living will. Oh boy. So while the complaint points to Newman's living trust, the complaint doesn't cite the foundation's governing document, which would detail whether the foundation is mandated to distribute $400,000 to the daughters annually. We should know that. Paul Roy, an estate planning attorney at Withers, who isn't involved in the matter. I love that's so attorney. I am speaking to you because I have not consulted and I am not involved in any way in this matter, so I am not speaking out of school. Let me make that clear. Tells the Hollywood Reporter that Newman's wishes in the living trust over tells the Hollywood Reporter that Newman's wishes in the living trust over how the foundation operates aren't binding. Quote, it sounds to me like the trustees were directed by Paul to consult with the family members in making decisions on distributions, but that's not necessarily a legal right to decide where the distributions go, he noted. That makes sense because they're not directors. So if the living trust was changed in the months leading up to death, they can contest it and try to unwind it, but it's going to be a big mess if they try to unwind the entire foundation, because they're going to argue, well, we would have been more integrally involved with the foundation and we would have changed the writing of it. Oh my goodness. Oh my goodness. This could get very, very messy. And there might not be a ton that they can do. The board removed Forrester from his position as CEO in 2019 amid allegations of misconduct, including harassment and creating an unhealthy work environment, so it gets worse. The daughter's suit also claims the foundation was improperly paying him and his wife to fly first class and stay in pricey hotels. Well, I mean, I guess, were they traveling for work? I mean, CEOs tend to fly first class and stay at pricey hotels, but charities tend to rein that stuff in a little bit. So we've got a 34-page complaint. We will take a look at it. I just want to go peek at what's attached here. We're going to have to do a dive into this a little more, but there's a chart. Sorry. We've got to get back to the crypto couple, by the way. Speaking of all the charts, that federal case was fascinating. You know I love a chart. Newman Family Foundations, Newman's own foundation, daughter's separate foundations, operating cost, trust, charitable gifts. So they were saying this was the flow of money. This was the plan for the flow of money. And let's see, it said daughters. This looks like a 5. It could be a 6. But it could be a 5 if somebody's predeceased. I don't know enough about the Newman family to know. So this is from 2006. This is from 2007. So they're going back and talking about the declining health and mental capacity, the overtaking of the trust. And let's see, are there any attachments? It looks like they're cited, but maybe not attached. All right. Well, if they're cited and not attached, I will try to go to the state court and pull it and see if the attachments are there. But if you want to read it yourself before I get to do a deep dive into it, this might have to be a podcast episode. I'm so interested. And Valerie is asking, Paul Newman passed in 2008. Why did the family wait so long to bring this up? They were probably getting the $400,000 they thought they were entitled to year over year. And when the money got halved, they were like, no, that's not okay. Possibly. So we will talk about it. And yeah, unfortunately we've got a lot else today and we probably don't have time to deep dive into this, but I think it's probably right for a podcast episode because I need to know what is being reported that went on closer in time to his passing. So there's a little research I want to do before I dive into this complaint, but if you guys are interested, let's put up a poll. If you don't mind, Miguelina, let's put up a poll. Do we need to do a deep dive into the Newman's own charity? And I'm not doing a deep dive and a taste test, though in my mind, it's like, do we need to determine what our favorite products are and do a deep dive? But let's put up a do we need a deep dive on this? I want to know what the chat says. You guys get to help decide the direction of the content because we need to be if we're all curious, we need to know. So, let's see. Victoria says, I believe that it's common knowledge that the Newman company has always been a family business. What do you think? I think that it seems like at least these members of the family aren't on the board. But now I want to know if there are any family members on the board, what the other siblings are doing, what the other siblings have had to say, if anything, and things like that. Like, I have so many more questions. So I see a lot of yeses in the chat. Don't forget to put up the poll. I'm very, very interested in this. So, and it brings up a lot of questions, not just of trust and estate, but of what can you do if you suspect that a family member might have been taken advantage of. This typically happens when there's money involved because there's not a lot of value in manipulating a family member. If there's not any kind of real property to fight over, it doesn't mean it doesn't happen. It's just, it's tough. Understanding your rights in different states is tough, but once you are an adult, you need to make sure that your adult family has things in place that are very clear and that you know where they are, because also dealing with somebody passing without any of that, passing intestate, is really difficult to deal with and can be expensive and can leave you with bills. But you need to have these things in place for yourself as well. Sorry to be a lawyer. It's awful. It's awful to have to talk about what happens if something happens to me or to my spouse, what happens to my kids, who takes care of them, the house, the pets, whatever. But if you don't want the state just taking your property, make sure that you have something. So we need to know. We need to know. All right, let us move on. We're going to talk about Britney next. And then we are going to talk about all of the Chrisley things. I've seen a lot of you asking if we're talking about both. We're going to start with the federal stuff and we'll see how much time we have, because some of you want to. Go ahead and vote. We're going to end the poll in just a minute as we get into the Britney story. Debbie D.O.B. said, happy birthday, Lauren. It's my birthday as well.
Happy birthday, Debbie. Yay!
Oh, the voice changers. The voice changers are going to become a thing. Have you heard Britney's new song with Elton John?
Yes, I have. I enjoyed it. It's a bop. It feels like dance music.
It feels like dance music. I enjoy that about it. I enjoy that it's cheeky. I enjoy that it sounds like Britney's singing lower in her register. I feel like with the song coming out, she has found her voice. I'm going to do an I Have Thoughts episode over on Patreon about Britney's 22-minute video talking about the things that she experienced. A lot of it for me echoed the things that she has said in court. So I will absolutely be giving kind of my deeper thoughts on that. It's a little, on this channel, we really just cover what's in court, what's coming up in court, and on occasion, if something can go to court. But this is absolutely kind of related. So the Emily Reacts stuff, like Emily as a human reacts, not just breaking down the law stuff, goes on the I Have Thoughts podcast over on Patreon. So I will be talking about that more there. I'm glad that she put it up. I don't know why it came down. It echoed a lot of what was in court, and the things that she said have been very consistent for me. Elizabeth said, I was a teen in the 80s. Kids today have absolutely no clue. They don't. The world is just so different. And while they have easier access to things, I also think there's some things that are a little harder to navigate. Their lives are so documented. I think that's got to be hard too to navigate. I mean, as we're trying to figure out how to navigate it as a parent of one teen who hates social media and a preteen who wants nothing but to drop out of school and be a YouTuber like Mr. Beast. So we're navigating both ends of the desire to be on social media with our children. And it's hard to navigate because he's like, why am I wasting my time with this? I just want to be a YouTuber. And it's hard to be like, because you have to finish elementary school, buddy. Like, there are things you need: reading, writing, math. We need some of those things. So Abro asked, did you see Britney's 20-minute audio that she posted on Twitter? I know it was up on YouTube. I know it's still up on YouTube. I posted a link to where it's been reposted on YouTube. It is nice to hear her just talk. It was. I escaped Northampton to Fort Lauderdale. I mean, much warmer in Fort Lauderdale. Luis Lemon said, I watched you on TED. Loved it. Thank you. Let's see. KB, will you be talking all Todd Chrisley lawsuits today or just his federal one? We're going to see if we have time for all. I have them all pulled. It's 4 a.m. in New Zealand. Excited to watch a live. Thank you, Kiwi girl, for being here. Joining you on my due date, Elizabeth Mullins. Congratulations. Still pregnant. Your videos always help with my stress, including now. Thanks for that. Babies happen when they happen. It's always stressful. It's going to be stressful. My best advice is it's okay to set boundaries. However you feel, you're going to feel. Your emotions are going to be absolutely wild after giving birth. It's totally okay. But if you need everybody to GFO, just tell them to GFO. If you need everyone but one to GFO, it's fine. Protect your space, protect your energy. You matter most. Take care of you and baby. It's okay to set boundaries. It's sometimes hard. You feel a lot of obligation, which is weird. It's like, why am I obligated to like entertain visitors right now? It just, please let me be. So it's okay to just be like, let me be. Dear Dana said, love you, Emily. If all family members are on the same page, sounds like there is a problem to me. I don't know if it's all family members, but we will see for sure. Sharing in the happiness of the pumpkin cold brew. Yum. We love a pumpkin cream cold brew. All right. The results of the poll. Do we need a deep dive into the foundation? Yes, 87%, no, 12%. Well, the eyes have it on that one. All right, let's officially swoop in and talk about Britney. We've got a lot of minute orders to cover. I'm going to do a very brief, brief. Keep me to it, chat. A brief road so far. Here's where we're at with the Britney case. All right. With the Britney case, we are still in court fighting mostly over money. This is over the 12th accounting that's not done. Who's going to be taking accountability for what? Who's going to be deposed about what? There is, James Spears seems to have been deposed. It seems that whatever came up in that deposition is going to be coming up with regard to TriStar. There's been allegations that TriStar may be paying James Spears legal fees. I don't know if that's true. There are allegations of that in some of these legal documents. There are ongoing matters in court, and the big ones are the motherfucking 12th accounting. This is the accounting with the media matters, with Holland and Knight, with millions of dollars to all the lawyers. How much are the lawyers going to get paid? Blah, 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 blah. The 12th accounting is still pending. I think there's going to be a full-ass evidentiary trial over this 12th accounting. Who's getting deposed from TriStar, what the depositions are going to cover, et cetera, that is still on the table. And there are other matters of pending money to lawyers. So everything that's still pending in court is about Britney's bag. All of it. We're not done yet because the 13th accounting still has to be filed. When I was in court in July, and I will be back hopefully the next time this is in court. When I was in court in July, the court was asking James Spears' attorney, Yeated Spears' attorney, Weingarten, and was just like, excuse me, when are you filing the 13th accounting? And he was like, we need to finish the 12th accounting. And I say this every time. Why? The 12th accounting is done. The accounting is done. The court has not approved all of the funds to be paid. Court approval doesn't mean the 12th accounting's not done. The 12th accounting's from the 12th year of the conservatorship. So the court's like, when are you filing the 13th accounting? Well, Your Honor, we want the 12th accounting to be done. It's like, it felt like an argument with your kid where you're just like, I need you to put on your shoes. And they're like, I want to finish this round. And you're like, but I need you to put on your shoes. And they're like, but I want to finish this round. And you're like, we don't have time for this. And by the way, you're playing like Minecraft. There's no rounds. Like, I need you to be done and put on your shoes so we can go. That's exactly what it felt like to me listening to the court going, when are you filing the 13th accounting once the 12th accounting's resolved? No, the 12th accounting's done. It's just not resolved. This is the first accounting that they have fought over because Sam Ingham, under pressure, it seems, from Lynn Spears, stood up and said, we have a few questions about where all this money's going for the first time. Could other accountings have been fought over in the past? Nobody did. Nobody did. But also Sam Ingham was making over $500,000 from being, Britney's attorney year over year. So was everybody just kind of on board with rubber stamping this shit? Seems like it. Until the 12th accounting, when somebody finally stood up and was like, wait wait a second, this seems like a lot. Some of the money that's being fought over is money that is supposed to go to TriStar. So the judge has not been aggressive with them yet. She was saying it needs to get done, and they kept putting it off. It's going to keep happening. So we need to keep an eye on what's going on these minute orders, because I am not taking my eye off this 12th accounting. If this goes to an evidentiary trial, I am going to LA and I am going to watch every single minute that I can watch of that evidentiary trial. I have questions, I want to know, but I really want to see Judge Penny step the fuck up, put her foot down and say, no, this is the date certain, and then I will file an order to show cause, and then I will start sanctioning a bitch up in here. Are we clear? Work on the 13th accounting, get it done. Get it done. Because every time they fight with Britney, they're then trying to bill Britney for it. Don't get it twisted. Yeeted is still trying to bill Britney for his lawyers still fighting in court over her money. So every time they pick a fight with her, they're still trying to bill her for it. The other thing is, Andrew J., different Judge Penny. So Judge Penny Ascarati in Virginia is Judge A. Judge Penny is Judge Brenda Penny in LA, different Judge Penny. Totally different Judge Penny. Judge A would just be like, this is not what we're doing. We don't have time for this. This is not how we move a calendar along. I've seen a lot of questions about why there haven't been criminal charges. It's questions I've seen Liz Day, an amazing reporter from the New York Times, ask. I've seen others ask these questions. Part of me wonders, and this is my supposition, part of me wonders if they want to make sure everyone can be deposed. Once there is a criminal investigation pending, there's a lot more room to plead the fifth on shit. And there is time for this. There are statute of limitations time for this. I think they're trying to get people deposed because Rosengart's first priority is his client. Getting her money back, figuring out where it went. Putting people in jail is not his first priority. Getting to the heart of where all the money went is his first priority for his client. And I think that's why we have not seen this move forward. I think it's to make sure people can be deposed. That's just my guess here with all of this. So let's go to these new minute orders. We're just going to go one by one and pull these up and go for it. So we're going to go through every single one of them. Most of them are from the 24th, even though they didn't post to the court website till later because I tried to pull them up then. And then another one is from just yesterday. So let us pull these up. All right. I should swoop again. Minute orders. We're into the minute order. Yay. All right. Let us go. This is from August 24th. There were multiple matters on calendar. Nature of the proceeding. Motion to quash filed on November 5th, 2021 by TriStar Sports and Entertainment. A motion to quash is your motion to squish your subpoena to make sure you don't have to deal with it. Squish. So every time you see quash, you can just think squash or get rid of. This is the motion to quash the subpoena. Hey, we don't want to come and be deposed by Rosengart. Who would? I mean, he's definitely not letting up. Let's see the tea on who was in court and who wasn't in court. The matter is called for hearing. LA Court Connect appearances by. So this is who is on the call. Oh, so Weingarten wasn't in court. Interesting. Weingarten, Brojstian, Geraldine Weil, and James Spears were on court call. Everyone else looks like they were in court. So this was not a day where Weingarten had much to do. Otherwise, I assume he would have been in court because it's really hard to speak over someone in court. It's much easier to speak over someone on Court Connect. And there was a bit of that going back and forth between Rosengart and Weingarten. There seems to be no great love lost. The court has previously issued a tentative ruling. It was an extensive tentative ruling. Argument resumes. We had reached the end of the day at the end of July when this came up because so much had gone back and forth with Rosengart and Weingarten. I covered that pretty thoroughly, though maybe a little scatteredly, in a live stream right after court and then in another stream after that. Or in a podcast after that. So we've covered it. So argument resumes, counsel for TriStar and counsel for Britney. The court finds that all evidence in support of and or in opposition has been provided for the court on this ruling. The motion to quash filed on November 5th, 2021 by TriStar is taken under submission on this date. I need to know what happened in court more. I need to know. Because the court had a tentative ruling and Rosengart came out of court on July 24th, 27th, whatever day it was, and was like, they're going to have to sit for depositions. We're going to get to ask everything we want. The court had made a pretty thorough tentative ruling, mostly in Britney's favor, but the court had not finalized that ruling. And I was like, that seems a little optimistic at this point. And here's the court taking it under submission. We're going to find out what happens to this in just a minute. Let's look at the other matters because the court issued a ruling, kind of, but something went down with this motion to quash. This is the 12th accounting. Accounting conservatorship filed on August 6th, 2020. This 12th accounting, the court finds that additional evidence by supplemental declaration or additional documentation is required to grant the matter on calendar this date based upon the reading of the moving papers. The accounting filed on August 6th is moved to Wednesday, December 7th at 1:30 in this department. Me writing down dates to be in LA. December 7th. How much do I love traveling in December? None. Will this get put over? Possibly. But if it doesn't, I need to know. All right. Let's see. This would have been so much easier if I was still just living in LA. Can we all just come to Tennessee? Wouldn't it be easier if we all did a triple? Just kidding. All right, let's continue. Petition allowance of fees filed on December 15th, 2021 by James P. Spears. I covered this a while back. This is additional attorney's fees where James yeeted Spears is like, hey, can you please pay my lawyers? And Rosengart's like, hold on. What's Rosengart like?
No.
The matter is called for hearing. The court finds additional evidence is necessary. The petition allowance of fees on December 15th, 2021 is continued to Wednesday, December 7th. It's 2 votes for December 7th. Great. Moving on to the next matter on calendar. Stuff's just getting yeeted over. Emily, does this happen in court all the time? Yes. On to a next date, on to a next date, on to a next date, on to a next date. It's exhausting. Petition allowance of fees filed on March 26, 2021. This is legal fees. Yeeted is like, hey, can we get more legal fees? Guess what? This is also going over till December 7th, 2022. Great. Everybody must be busy if these are all getting put over till December 7th. Order to show cause. This order to show cause is a WTF you haven't filed the 13th accounting. This has also been put over till Wednesday, December 7th. It was absolutely center stage. That's the first comment I saw that got my reference. And yes, it was. I love Center Stage. It's a great movie. It's a great movie. All right. This is the matter taken under submission. This is the most important thing. Everything else got yeeted to December 7th. August 29th. This judge, she waivers. She gives them room and then she waivers. The tentative ruling on the motion to quash was substantial. just absolutely substantial. And she wavered because here we go. Because here we go. Here the fuck we go. Here we go.
Here we go. Here the fuck we go.
She wants more briefing. The following parties are present. None. So this was the matter taken under submission. Under submission is the judicial, I need to think about it. This works very well with children, spouses, parents. It's like, can I get this game? Can I do this thing? Can we come stay for the holiday? Whatever it is. It's like, I need to take that under submission. That is your judicial, I need to think about it more, or I need to research it more, or I don't have time for your shit today and I don't want to make a decision because I'm mad. I need to take it under submission. Just this, when you're working legal into your everyday life, this one and objection non-responsive, these are the things that are the most helpful. So taking the matter under submission, I need to think about it. Out of the presence of the court reporter, the court makes the following orders. The court, having taken the above captioned matter under submission on Wednesday, August 24th, hereby rules as follow. After further consideration of this matter, the court questions whether the requested documents in requests for production numbers 10, 12, 13, 16, 17, 18, 21, 22, and 23 were previously produced to Ms. Spears and her counsel as part of non-party TriStar and Entertainment Group's document transfer to Miller Kaplan. Hey, you might already have it. And if you already have it, we don't need it. And this is what TriStar has continued to say. TriStar has kept saying, we already turned the production over. The document production is the requests for discovery that are going on before the deposition. Accordingly, this court's order submitting the matter for decision is vacated. Okay. So it's no longer under submission. The court orders further briefing to specifically address whether the requested documents were produced to Ms. Spears and her counsel. Your Honor, they have been in court twice on this matter. Couldn't you have just asked them? Why does this need additional briefing? So the court wants additional briefing. Did you turn it over? Did you not turn it over? Does Miller Kaplan have it? Okay. Ms. Spears shall submit a supplemental declaration not to exceed 10 pages by September 13th. Non-party TriStar shall submit a supplemental declaration not to exceed 10 pages by September 13th. Both briefings are to be served on all parties. Did they not know in court? Could you not just ask them, did production number 10 get sent to Miller Kaplan? Yes or no? Unless she asked Rosengart and he's like, I don't know, Miller Kaplan hasn't told us. But it seems like Rosengart would go to Miller Kaplan, who's the intermediary business manager, would go to Miller Kaplan and be like, do you have this shit? Before fighting with TriStar over it. Rachel Mills said she did ask. So, which is possible that they just don't know. But if they don't know, they should have, Rosengart should have been clear from Miller Kaplan before they did this. TriStar should have been clear about what they turned over and said, this is our document production. This shows it. So to have to go back and do it again is either the judge or the attorneys. Somebody is not getting it done when we need additional briefing. Maybe we will see that in the additional briefing. We generally see Rosengart address the court directly. Your Honor, on this date said this, and then normally a little bit of, oh, wise, Your Honor. Oh, so great. Oh, thank you. And we normally get a little bit of information about what's going on. So, September 13th, perfect. I'll be traveling for a concert. But when those hit, I'll cover them because I'm very interested. And when we cover them, I'll pull up the original motion and go through exactly what production numbers 10, 12, 13, 16, 17 are. These are requests for documents. Give us these documents. And then they're fighting over whether the documents have been turned over or not. That needs to be That needs to be cleared before they move on to whether or not a deposition needs to happen. So, with that, we are going to see by September 13th more briefing. Will anything else come up before then? No, because everything else went over till December 7th. If there's more hearing to happen on this, this is going to go over till December 7th. I'm not surprised with Thanksgiving coming up. Generally, from my experience in criminal court, civil court tends to follow similar patterns. You get this lull in like the end of August and September as kids are going back to school and people are trying to get their trial schedules to go. And then you get this rush of activity between the end of September and mid-November. And then you get a lull again between kind of Thanksgiving and Christmas where people don't want to go to trial. There's a belief that juries are cranky if they have to be on jury duty between Thanksgiving and Christmas. And it's just it's a difficult time of year. So we see these kind of ebbs and flows in court. I'm not surprised that they probably are trying to, or the attorneys are busy between now and December, and that's why the court just set it over. So December 7th. December 7th is when this will be back in court, and it'll only be on a half day. And I guess we might be in Los Angeles in December again. We will see. But next time I'm in LA will be the end of September. We might do a meetup. I'll tell you more about it later, but we might. We're having conversations about how we would make that work. So we might do a meetup. All right, you guys, it's almost an hour in and we are just getting to talking about Todd Chrisley and Julie Chrisley and their accountant. We're not going to talk about the accountant too much. There were 3 defendants in this trial. We're going to look at these motions for new trial to see what Todd Chrisley thinks went wrong in the trial, but we get some more indication of the testimony. This trial wasn't covered super heavily by those present in court. I don't know if there were a ton of people in court. It just kind of came and went during the Depp Heard trial and the Chrisleys were convicted. I did a podcast episode breaking down what they were charged with and the reporting that I had seen about their conviction. They had talked about it briefly on their podcast, that they are, they believe, just briefly, like they believed that they didn't throw the jury under the bus. They talked about, we are still praying for the best and moving forward and we will see. So let us get into the Chrisley motions for new trial, and we will get to a few more super chats before we do that. I see a few more in-depth questions. I'm going to save those for Q&A. So don't worry, when we get to Q&A, we will get there. Kate said, actually got to catch a live. Haven't been here much lately because work has gone back from vid hours to insanity. So happy to be here. Happy that you're here. I know that absolutely happens. Tessie says, pastor's kid here, please, for the love of all things you hold holy, make an annual day to keep your affairs in order. I have PTSD from people fighting over the smallest crap. Yep. It just is one of those things that we don't always think about. And these are the things you don't get taught really how to adult in the world that has a lot of rules about shit. It's just wild. All right, let us move on to Chrisley's and then we will get to Q&A after this. I'm sure there's a lot. And I love Q&A. I love chatting with you guys. But first, there's a whole bunch of motions coming up. So let's go to the Chrisley verdict form. And again, just do a quick refresher. If you want to deep dive into this, I did a full podcast episode about the Chrisley convictions. If you want kind of an up to speed on these federal convictions, are they facing time in prison? Yes. Is it a lot of time? Yes. Are there a lot of counts? Yes. So this is Todd Chrisley, his wife, Julie Chrisley, and then Peter Tarantino, the accountant. The verdict form, this goes to Todd Chrisley for the first counts. Count 1, 2, 3, 4, 5, 6, 8, 9, guilty. So some of these counts went to other defendants, and that's why the numbering's not even. These go to Julie Chrisley, count 1, 2, 3, 4, 5, 6, 7, 8, 9, 12, guilty. That 12th one is an extra obstruction of justice. Most of these are defrauding banks. Some of them are tax related. Again, full breakdown in the podcast. And then as to the accountant, count 8, count 10, and count 11 guilty. Signed. It's interesting that they actually didn't redact the foreperson. different courts do things differently. Let's get into the Chrisley's joint motion for new trial. This is a motion between all the defendants saying, hey, we believe there should be a new trial. At this point, law nerds, you've watched enough trials where you're like, with that, you get a conviction, and then there will be a sentencing date, and there will be motions. There will be motions for new trial, motion to set aside a verdict, motion for a judgment notwithstanding a verdict. There will be these motions that happen after trial. This happens in almost every single case. Civil cases have them, criminal cases have them. Every case we've covered, we continue covering the post-trial motions when we see them. Don't worry, there will be some coming up in the Theranos case, I am sure. Joint motion for new trial. Your Honor, shit happened. It shouldn't have happened. We're entitled to a new trial because of the shit that happened. That's what we're going to see here. Introduction. The rules allow the court to vacate any judgment and grant a new trial if the interest of justice so requires. What the interest of justice is very broad and a very hard standard to meet. The 11th Circuit, and of course this is in Georgia, so the 11th Circuit has defined the interest of justice as a broad standard that is not limited to cases where the district court concludes that its prior ruling upon which it bases the new trial was legally erroneous. So this is setting out the legal standard. The Chrisley's trial was fundamentally unfair in two respects. Okay. First, the government presented and failed to correct false testimony from IRS revenue officer Betty Carter, who lied about the Chrisleys owing taxes for years when she knew no taxes were due. So this is alleging that someone committed perjury by giving false testimony at trial. This testimony had the effect of falsely painting the Chrisleys as untruthful, likely to commit other forms of fraud, and evading the tax payments alleged in the indictment. Second, at the government's insistence, the court admitted substantial volumes of evidence at trial which were obtained in violation of the Fourth Amendment, even though this evidence had been suppressed under this court's prior rulings. That's interesting. Without requiring the government to make any showing at all that the evidence should not be excluded. Often, if evidence is suppressed, it doesn't come in. If things are obtained in violation of the Fourth Amendment, generally the appropriate rule or the appropriate response by the court is to suppress most, if not all of it. So it's odd to me, we're going to see the responses from the government. I'm going to cover those too. It's odd to me that evidence would have been suppressed by the court and then nothing would have happened and it just comes in at trial. I have a big question about that because that's not the way that generally goes. That's not the way that generally goes. So I have questions. I'll be interested to see the response. That shouldn't happen in general. By relying on a putative but non-existent procedural error, the court avoided addressing the substantive problems with the government's evidence. That's interesting. And interesting, we will need to know. Heather Copeland asked the question, did the lawyer object at the time? We don't know. If they didn't, I'm sure the government will point it out in their response. They're sure not going to point it out in this motion if they didn't, unless they have to address it. Either issue on its own justifies a new trial. And again, if this gets denied, these might be issues for appeal. If all of this is taken at face value, I'm not saying you should always ask questions, but if evidence was suppressed and then was allowed to come in at trial, that could be an appeal, like a legitimate issue for appeal. Issue 1, false testimony. A new trial is necessary because the government presented and failed to correct false testimony. Oh, did it come to the court's attention? Like, I have questions. Did they have the opportunity to correct it? Did we know it was false? Like, what the fuck is happening? The Supreme Court has observed that deliberate deception of a court and jurors by the presentation of known false evidence is incompatible with rudimentary demands of justice. It's interesting that that's how it was written out in Giglio versus the U.S. Sometimes I call it Giglio. Sometimes I call it Giglio. It is a landmark case that is used quite a lot. It is also explained that, quote, the same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. The government is guilty of both evils here. At trial, the government presented the testimony of IRS agent who testified that Todd and Julie Chrisley had not paid their federal income taxes for many years and owed the IRS untold sums of money. When pressed, the officer swore that she had confirmed her claims in the IRS's internal system the day before her testimony, and those records showed that the Chrisleys owed taxes for at least the years of 2014, 15, and 16. This was all false. Their attorney should have had the records then, or the proof then, to impeach this witness. I think that would be the way you would generally handle it, is impeaching the witness. Shortly after trial, Officer Carter contacted... What? Shortly after trial, the IRS agent contacted the Chrisleys' accountant to admit that the Chrisleys had paid their taxes and owed the IRS nothing. Wait, for those years? I need this to be more specific. For those exact years, or like up to now? Was it paid after trial? I have so many questions. That's going to be an interesting matter for a hearing. That's going to be a very interesting matter for a hearing. But why wouldn't this have been cross-examined? Okay, I have questions. But the jury never heard the truth. Instead, the jury was left with the false impression that the Chrisleys continued to avoid paying taxes for those years. This is false testimony that went directly to the Chrisleys' character for truthfulness and credibility, corrupting the trial and violating their due process rights. A new trial is necessary to correct this injustice. Okay, let's look at the background. I've got some questions. Look, there are times when appeals are warranted, and there are actually questions here where I'm like, if this went down the way they said it went down, this is a problem. Now, again, we will get the government's recitation of how it went down, and then we will look at both of them together and go, okay, this is why we need both. But for now, we've got this one. Relevant background. IRS agent testified that she prepared for her testimony by examining the relevant tax payment records through the IRS's internal systems. She swore that she reviewed the IRS's integrated data system, which, quote, shows returns that are filed, taxes that are due, payments that are made, basically the activity on the money side of the account. That cites the trial transcript. Purportedly based on her review of those records, the IRS agent testified that the Chrisleys failed to pay taxes for various years and still owed the IRS money for these years. For example, she testified that based on her review of the records, which she completed the morning before her testimony, the Chrisleys owed taxes for 2010. Question. Ooh, we love testimony. Question. Have you seen Todd and Julie Chrisley's 2010 joint return? Well, who's asking the questions? Could you have clarified which attorney's asking the question? I have questions. Have you seen Todd or Julie Chrisley's 2010 joint return? I have not. You've never seen it? No. Oh, okay. Have you seen Todd or Julie's 2011 tax return? Not specifically, no. I know they had balances owed, but I haven't seen the actual return. Okay, for 2010, are you aware now that there are no taxes owed? Answer, I'm not aware of that. There is taxes owed. Question, not on, you believe there is on 2010, question mark? I checked them this morning. Yes, emphasis added. I need the rest. What happened next? In addition, when asked whether she knew that the Chrisleys did not owe taxes for 2013 or 2014, she first testified that she was unsure. Question, you're a revenue officer who's looked at the filings in this case. Well, she just said she didn't see the filings. Have you seen the return? No. Have you seen this other return? Nope. So maybe didn't see the filings. Who's looked at the filings in this case, and you're aware that tax returns were filed in those 2 years. Now they have been, yes. Question, yes, and the amounts owed are zero. Did you know that? I'm not sure that's accurate. Question, this sounds like cross-examination to me. Question, the tax returns that were filed with the IRS. Answer, which years are you talking about? Oh, good God. This was an interruption. That's why there's a line here, because this was a talk over. For the 2013, 2014, the amount of tax owed by the Chrisleys is zero. Did you know that? No, I did not. She then testified affirmatively that the Chrisleys' taxes were not paid in full for 2014 and that she confirmed this fact the day before her testimony. Okay, now in 2014, there was a balance of about 77,000 that was fully paid, correct? 2014? Yes, that's not accurate. Question, okay, do you have your schedule there of payments and the like? No. Question, in fact, the final return for 2014 showed zero, correct? That's not accurate. This does sound like cross-examination. You don't believe that? I checked yesterday. There is a balance owed for 2014. No, the return. The final return for tax year 2014 shows zero. Is that correct? This is me now just adding in color commentary. It probably didn't go that way in court. I don't know about the return. I know there's an outstanding balance for 2014. Officer Carter also testified. See, I'm going to screw up at some point and say Agent Carter. I apologize. It's just my brain because nerd and because they are an IRS agent and it's weird to call IRS agents officers. But anyway, we're gonna continue. I'm very curious. Officer Carter also testified that the Chrisleys owed money for 2015 and 2016. When she could not recall the exact amount, she was adamant that the Chrisleys had not paid their 2015 and 2016 taxes and indicated that she would look up the exact amount after her testimony and notify defense counsel. Question, let's go to 2015. Isn't it true that neither Todd nor Julie owes a penny? That's not true. Any idea of the amount? I can give an approximate amount of what they owe for everything that's outstanding. Where are the records? Like, where is the records? Where are the records? Karen, I know that IRS agents have had guns, well, their enforcement division, for a very long time. So this is not, it's not new. I think it's becoming publicly aware, but it's not new. But I worked in the U.S. Attorney's Office tax division in law school. And so I knew had the opportunity to meet a lot of IRS agents, but back since the early 2000s, that has been the case. And I think before then as well. So not new, just I think more publicly aware. Anyway, as we digress and move back over, where are the records? Like, why aren't we just admitting the records? Where are the records? Where are the records? Like, why are we relying? Okay, this is someone else's choice, not mine, but it just seems like, here are the records. They say this. And then you can just establish them by business records. Why are we doing this way? Okay. I wasn't there. We were in the middle of another trial. I can give an approximate amount of what they owe for everything that's outstanding. No, we don't want to guess on the record. That's the defense absolutely doesn't want that question. I don't want you to guess. I really don't. Nope. Don't want you to guess. Do you have a number for 2015? No. Question, would you get that for us? 2016. Isn't it true? These double negatives get so confusing. Isn't it true they don't owe any money? 2016. They don't owe any money, correct? No, they owe. Do you know the number? No. You'll let us know? Yes. Agent Carter did not contact defense counsel during the trial to let them know how much the Chrisley owes, as she indicated she would do. Instead, she waited until after the trial. At that point, we don't know how many days were left in trial based on this motion. I'm sure the court does from when this individual testified. At that point, when the government had obtained convictions they were after, she spoke with the Chrisley's accountant, Bruce, and admitted that the Chrisleys did not owe the IRS money she claimed at trial that they did. That's a confusing sentence. See Exhibit 1, declaration of, oh, good. Is the declaration attached? Cool. We're going to hear what we're going to see what that conversation was. According to the officer, the Chrisleys were current on their taxes for 2014, 15, and 16, but the IRS had failed to apply the payments to their account. Y'all, I can believe it. That's the sad thing. I can believe it. I can believe that the IRS in their system is like, our bad. We didn't apply it. Like I can believe that. Oh, this could very well be a big problem. This could very well be a big problem. Y'all have accountants, man. The US, for the international audience, you're like, what the fuck? Here's how it goes in the US. This is just me being hideously skeptical. Figure out how much you owe. pay us. Hope that we apply that properly. And you can go to jail if we fuck it up. You're bad. I can see this happening. It doesn't mean, again, it doesn't mean that the Chrisleys didn't do anything wrong, but it does mean they might be entitled to a new trial if this was allowed to be hanging. It doesn't necessarily mean that the agent perjured herself. If the agent is like, oh, I just checked it and didn't look any further, but then I looked into it further and found that they failed to apply it to the account. So in our records, it showed that they owed, but they didn't. What the fuck? I mean, I can believe that this happened, but by the time you're going to trial, you would think that they would have the manpower to like double check, because you could end up needing a new trial because of this. I don't know if that will happen here. We're going to have to see the government's response to this, but this is a problem. This is such a mess. Y'all keep your records, man. Keep your records. Because when the IRS is like, you didn't pay us. No, you need to be able to prove it. Look, with the IRS, you are not innocent until proven guilty. You have to be able to prove it to them and fight with them on it. And it sucks. But I can absolutely believe that. Oh, this is messier than I thought it would be. I love a good first look. We love a good first look. We love a good first look. Like, if we just went to like a flat tax, me being conspiratorial, if we just went to a flat tax that you kind of paid on everything you did, then we wouldn't have to fuck around and find out. Like, I think I owe this much. Good luck. Oh, but our tax code's used to manipulate the populace into doing things that lobbying group wants. All right, that's enough of me for today with that. You know, our tax code is so thick with like, hey, if you buy a SUV that weighs this much, you get a deduction. If you own a small business, have fun buying that new Porsche, because the automobile industry sees their SUV sales are declining. Our tax code is so complex with benefits and loopholes, and the people who benefit are writing in the loopholes. It's just, I could go on. I could go on. I could go on, but I won't. Just, anyway, we will continue. In email, oh, there's an email. There's an email. There's an email. Y'all, per my last email, what the fuck's happening? In email correspondence following the call, Officer Carter confirmed that the IRS system showed that the Chrisleys had made payments for 2014, 15, 16 that exceeded the amounts owed for those years.
They paid more? What? More than they owed?
Y'all. It's in an email. Put more simply, they did not owe money for the years that the officer swore at trial that they did. Her testimony left the misimpression that the Chrisleys still owed substantial sums to the IRS, when in fact the IRS had been failing to apply the payments that the Chrisleys made. All told, the IRS owed the Chrisleys substantial refunds, not the other way round. Oh boy. This is a look. Appeals don't often win, but this is a problem. This is a problem. This contradiction was not a mere mistake. Despite whether the payments the Chrisleys made had been applied to the balance or not, as Officer Carter asserted to Bruce, she still would have seen them in the IRS's data system.
What? This is more tea than I expected. The witness who testified.
I can't do this in a voice. The witness who testified admitted that she still would have seen them. Was she not looking? Oh dear. Oh dear. Oh dear. We're going to have to do a deeper dive into the Chrisley conviction, y'all. Oh dear. I need to know more. I need transcripts. Okay. This contradiction was not a mere mistake, despite whether the payments to the Chrisleys made had been applied to the balance or not. As Officer Carter asserted to Bruce, the accountant, she still would have seen them in the IRS's integrated data system, which she confirmed she viewed to prepare her testimony. See Exhibit 2. Oh, okay. And it was the same records that she referred to when speaking with Bruce, the accountant, that admittedly showed that the Chrisleys did not owe the IRS a dime at the time the officer testified. Rather, the IRS owed them a substantial refund. This information was not only available to Officer Carter both before her testimony and thereafter, but it was also further known to and available to the prosecutors. Oh, that's a problem. Because then they have to turn it over to the defense. You don't fuck around and find out when people's liberty is on the line. You shouldn't fuck around and find out ever. But there are rules for criminal prosecutions. This is Brady evidence. This could be exculpatory evidence. Oh boy. Even so, Officer Carter was permitted to testify falsely and emphasize that false testimony when challenged under cross-examination. At no time did either Officer Carter or the prosecutors attempt to correct the statement. Oh, argument. There are 2 categories of Brady violations.
It's like I just said that. Yikes.
This is good for the Chrisleys. This is not good for the government. I am dying to know. I am dying to know how they're going to respond to this. I need to know. I need to know. There are 2 categories of Brady violations, each with its own standard for determining whether undisclosed evidence is material and merits a new trial. They're being accused of tax fraud. So tax records seem like they would be important. So the first category of violations are the Giglio claims, which occur where undisclosed evidence reveals that the prosecution knowingly made false statements or introduced or allowed trial testimony that it should have known was false. By the way, that's attributed, should have known, that's attributed to prosecutors even if they don't know. The should have known means if someone on the prosecution team, that includes law enforcement, if the IRS knows as an entity, the prosecution working with the IRS in this case is assumed to know. And this is where prosecutors end up screaming at law enforcement being like, what the fuck, man? You can't just not tell me shit. So they should have known that you can't try a tax case without all the records. Who wasn't looking at the records? Like literally, what the fuck? Look at the records, man. At least be curious. Just be nosy. Cactus Bill asked a great question. This is a very good question. I don't think I addressed it well at the beginning. This is a motion for new trial in the state court. If the court does not grant this motion for new trial, I imagine this will go up on appeal. So this is the beginning of the process, but it's just down in Georgia. I could get there. We could do that. We're just going to start going to court. Federal court, here we come. Because I want to see this argued in court. There's some tea up in here. Normally you look at a motion for new trial and you're like, yeah. But this has some teeth to it. I'd be pissed. With this information sitting on a conviction. If I'm the defense attorney though, I'm going to be like, I'm going to look at that email and be like, you know, the GIF from Pitch Perfect. Oh yeah, it's that. That's how the defense attorney is doing. With all of this. Okay, let's continue. Under this category of Brady violations, the defendant is entitled to a new trial, quote, if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. The quote unquote could have standard requires a new trial unless the prosecution persuades the court that the false testimony was harmless beyond a reasonable doubt. This standard favors granting relief. In a case where financial crimes are alleged, it's very hard to argue saying they still haven't paid is harmless error. The government knowingly used Officer Carter's false testimony and failed to correct it. Officer Carter's testimony that the Chrisleys did not pay their taxes for 2014, 15, and 16 was false. She admits this. See Exhibit 1. Can't wait till we get there. Going to keep moving quick. And the court can conclude that she knew the testimony was false when she gave it, and that, according to her own testimony, she checked the IRS's integrated data system,
which shows the payments.
The day before she testified. At the very least, Officer Carter should have known that the payments were made and visible in the IRS system when she testified to the contrary. Her actions certainly suggest she knew, although she testified that she would confirm the amount owed and notify defense counsel after her testimony. Neither she nor the prosecutors provided defense counsel with this information.
If there are emails showing that this agent talked to the prosecutors, or a conversation that happened and they didn't notify the court, this is going to get worse. Like, worse.
Oh, gosh. Oh. Because IRS agent Carter is a government agent, her knowledge is imputed to the prosecutors. Yeah, we just talked about that because I couldn't keep reading. Even if this were not the standard, there is evidence that prosecutors themselves knew her testimony to be false. For example, tell us. The government filed a motion in limine seeking to exclude evidence of tax payments that the Chrisleys made before trial. Well, when did they pay it? Now I need to know.
Was this paid like 3 weeks before trial? When was this paid? When was this paid? Because
here's the thing. If it was just paid before trial, they could say this was paid last week. And they could still say these were not paid up until last week. And because it's like, oh, well, if they weren't paid till last week, obviously they're paying it right before trial to try to look better in front of the jury. And then that can be discussed. But when were these things paid? Hopefully we will see that in the government's response. Oh, boy. There was no plausible explanation for filing such a motion, yet being unaware of the payments that the Chrisleys made before trial, especially when the prosecutors possessed and disclosed the IRS transcripts showing that no taxes were due for many of these years. Wait, what? If they disclosed them, why couldn't you have impeached this witness with them? And defense counsel repeatedly told them about the payments. Okay, what happened at trial? Did we impeach this witness with documents? Did the court not allow you to impeach this with documents? This was doubly true after defense counsel's attempted cross-examination of Officer Carter on the issue, which repeatedly raised the issue of these payments. The testimony could have affected the judgment. I can understand that argument. We're not going to get into the legal side of it because yes, we're dealing with whether or not payments were made. I've got a question about how this went down in court more. We're only seeing a bit of the transcript. I'm sure we'll get more perspective when we get the government's response. This is all the legal argument saying, look, in these other cases, it was a new trial was granted. Let's see. Is this where's your conclusion statement? Officers Carter's false testimony corrupted the trial. Her testimony smeared the Chrisleys' character and credibility and provided the jury with false information about their payment of taxes that bolstered the government's theory of the case. If the jury knew that the testimony was false, it would have impugned her credibility and the credibility of the entire investigation. I don't think that's a huge reach. For these reasons, the government cannot show that her testimony was harmless beyond a reasonable doubt. A new trial is necessary. This is probably the best argument I've seen on appeal. We're going, or on motion for new trial, because there were things discovered after the trial. I don't know why they didn't cross-examine this agent with documents more, because you can't hold it. If the defense knew, you can't hold on to it and then spring it up later. We saw that in Depp Heard, and Heard's like, this isn't the right juror. You can't hold on to a problem and then bring it up. It has to come up at the time, which is why I do want to see the government's response to this to get the other side of this story. But on this, not great. A new trial is necessary because the government violated Brady when it suppressed evidence showing the Chrisleys' tax payments. This is a second part of the same argument, and we've already seen the argument. So we're going to move on. Issue 2, admission of previously suppressed evidence. I am very curious about this. Very curious. Very curious. A new trial is necessary because the court admitted evidence in violation of the Fourth Amendment. At the government's insistence, well, the court can say no. The court admitted substantial volumes of evidence at trial that were obtained in violation of the Fourth Amendment, even though this evidence had been suppressed under the court's prior rulings. When it did so, the court did not require the government to make any showing at all that this evidence qualified for an exception to the exclusionary rule that would permit its admission. This was error. What happened? The chain of events leading to the error is long but easy to follow. So, we'll tell you if it's easy to follow. Let's crack on. The Georgia Department of Revenue, DOR, illegally searched 2 warehouses leased by the Chrisleys. While executing the search, DOR agents unlawfully seized financial documents they believed to be fraudulent. The DOR agents' actions were reprehensible, to say the least, but they're not at issue here. It seems like they're kind of at issue here. This court ultimately determined that the searches were unconstitutional and as a result suppressed both the documents the government obtained from the warehouses and all evidence derived from it. Those are fopped. Oh, we're getting into everything today. Those are fruits of the poisonous tree. So fruits of the poisonous tree is, you get one document illegally and then you're like, ooh, this leads me to that. Like if you do an illegal search or seizure and you find a phone number and then you do a search warrant for the phone number and get a whole bunch of shit back and, tie it to a Facebook page and get all the Facebook shit and then tie it all to whatever crimes you're investigating. If you got that phone number illegally and then got a search warrant for that phone number because of the illegally gotten thing, everything that comes from it is the fruit of the poisonous tree because the reason you got it was because of the illegal thing and all of it gets thrown out moving forward. So they're talking about fruits of the poisonous tree here and saying because of the first illegal search, you've then gotten to next illegal searches and then now we're fopped. I know. Yikes. I need to know more about how this went down, and I don't think we're going to know the full picture about this until we get to the response. But we had kind of set this case aside for a moment, and now I'm like, damn it. I am so invested. So the Georgia Department of Revenue illegally searched the warehouses, got the information. The government then got other information. Those documents were suppressed. The government didn't appeal. So how did they come in? What the fuck happened here? What is at issue now is whether the court properly enforced its suppression order. I mean, how could they not? The facts already in the record establish that nearly all investigative steps federal agents took after March 2017 were prompted by what was found in the illegal search. As a result, much of the evidence the government collected should have been inadmissible at trial. Well, you said that the court already ruled it inadmissible. But prosecutors sought to admit some of it anyway. I mean, they do that on occasion. The court should have said no. And when the Chrisleys raised the issue, the court declined to decide the question on its merits. Odd. Ruling sua sponte that the motion seeking to enforce the court's suppression order was untimely. Oh, there's more there. We're sidestepping around an issue that's here, but there's an issue here. The effect of this procedural ruling was to erase the court's prior substantive one and to permit the government to introduce fopped evidence of the illegal warehouse search without showing that it met an exception. This was grave error. A new trial is necessary. It's interesting because most of the time the courts won't fuck around and find out with that because the appellate courts do not like the government overreaching. But there's more to this. I need to know the timing of it because the court's not just going to be like, it's untimely, or shouldn't all like willy-nilly be like it's untimely. Oh, let's get to the relevant background. The Chrisley filed 2 motions to suppress evidence raising separate and distinct grounds for relief. The first motion to suppress asked the court to suppress evidence seized pursuant search warrants executed at the warehouses, not warehouse 13, but other warehouses. The warehouse motion requested the following relief: that, quote, all evidence obtained from the subject search warrants for the illegal warehouse search and all fruits derived therefrom be excluded as from evidence. The warehouse motion plainly asked the court to suppress the actual documents and records seized, along with all evidence derived from those. I mean, it has to be. It has to be. You have to ask all of it. A few months later, the Chrisleys filed a second motion to suppress on alternative grounds. This motion challenged the admissibility of documents the IRS obtained from Google and AOL. Lol. Pursuant to search warrants seeking emails and other electronic documents. Hey!
It's like my example was kind of on point. I need a fan. I love it when that happens.
It's just a, it's such a happy coincidence when we do a first look and we're all on the same page. We love to see it. All right. Here, the Chrisleys argued that the search warrants were fatally overbroad. This raised a separate attack on the evidence. If the first motion failed, it provided an independent basis to exclude at least the narrower category of evidence. After a 2-day evidentiary hearing, I mean, that's a substantial evidentiary hearing, the judge entered a report and recommendation on each motion, determining first that the Chrisleys' ESI motion should be denied, and then holding the next day that their warehouse motion should be granted. It's interesting that they did that way and they didn't do it the other way around. In the first R&R, the magistrate judge declined to suppress the electronic evidence because the warrant was overbroad. Nothing about this ruling, however, impacted or narrowed the court's ruling on the separate warehouse motion in which it recommended be granted. I read that awkwardly. In the second R&R, the magistrate judge held that the court should grant the Chrisleys' motion to exclude all documents and materials seized at the warehouse and all documents and materials derived from the illegal search. The magistrate judge explained, here's the ruling in part, quote, the federal warrant application itself expressly references what DOR told the federal agents about the contents of the seized material, that is, forged bank records. In other words, IRS only knew what these documents showed because DOR illegally seized them from private premises in the first place and told the IRS what those documents contained. I need more, but this is on the record. Damn it, this deep dive is going to include pretrial motions. Oh, me. Oh, me. As the R&R makes clear, the records discovered by DOR during the illegal search were what prompted the IRS to seek the records from DOR. Further, because the government cannot benefit from the fruits of an illegal search, it cannot conduct investigative activities using the information from the illegal activity. True. I still have questions about what happened at that warrant, but now we're going to have to go back to the pretrial motions and take a look. The government did not appeal the second ROR or R&R, so the court adopted it in its entirety. Adopting it in the entirety should have suppressed the evidence. They're saying thus the court's ultimate suppression ruling on the warehouse motion extended far beyond the physical documents that DOR seized. It suppressed all informations, documents, and records that the federal government obtained that flowed from it. The Chrisleys filed their motion to require proof of admissibility. When counsel for the Chrisleys attended the March 28, 2022 pretrial conference, they believed correctly that the status of nearly all documents and records the federal government obtained from the warehouse searches was settled. The court's prior ruling barred them from trial. And as the pretrial hearing began, this understanding held. The government said it did not intend to introduce any evidence seized from the warehouses or any evidence derived from the search at trial. Okay, so where did this go sideways? If everyone's on the same page, where did it turn? But then the prosecutors changed their tune. Later in this hearing, for the first time, the government suggested that it might have quote-unquote independent sources for the previously suppressed evidence it sought to introduce. This was news to the Chrisleys. As the magistrate judge noted in the R&R, quote, the government did not assert any independent source argument that is that the IRS or FBI were aware of the existence of these documents and the probable cause basis for seizing them, independent of the information learned from DOR, including the information provided as the contents of the forged bank records. So that was a lot of information. But what they're saying is, really, the government didn't say at the time, we know about this information because of this, because of this, because of this, because of this. So even if one of these things is faulty, we still have these other three bases that we're relying on. They were relying on the information from the Department Office of Revenue, and they didn't assert any other way that they knew it. So That's not going to be good. Let's keep going. In response to the government's claim, and I wonder what the government will say in response to these. Again, this is just the Chrisley's motion. The government will respond and then the Chrisleys will reply. In response to the government's claim that it had independent sources from some of the previously suppressed evidence, the Chrisleys filed a motion to require the U.S. to establish admissibility of suppressed evidence and brief in support 3 days after the hearing with the magistrate judge. That seems timely. I have questions. This motion specified 5 categories of evidence. I'm saving Lisa Valentine. I'm saving your question for when we get to questions. I saw it. We'll get there. This motion specified 5 categories of evidence that derived from the information that the DOR and the IRS illegally obtained because it was currently unknown what other information the government intended to introduce at trial. Fair. The motion specifically asked the court to enforce its prior order, excluding from trial any evidence derived. We're going to have to go and look at all those rulings. I have a lot of things to download. All right. This request was not new or belated. This request was not a new or belated suppression motion. I mean, fair. It seemed like they were all on the same page. The court had already made the ruling, and then the government's like, oh, we have some independent bases. And they're like, I'm sorry, WTF? It tracked the language of the relief request in the original motion, which the court granted. The Chrisleys explicitly recognized that the court has already ruled on the admissibility of this evidence. For the defense, this is how they saw things. It sounds like they are running up to trial because this is in March 2022, not long before they go to trial. They are running up to trial believing that a substantial amount of evidence against them is suppressed because the government fucked around and found out. When you violate the Fourth Amendment, you don't get to have your evidence. That is supposed to prevent the government from just kicking down doors and doing wild shit in violation of the Constitution. It doesn't mean it always works, but it's supposed to stop that because there's no benefit to it. You kick down the doors, you find out the information, you grab the documents, and it all gets suppressed. You can't use it at trial and you can't prosecute this person. It's supposed to stop that type of behavior. So if you let the government, have their cake and eat it too, it violates the Constitution if they violated the Fourth Amendment. So you can't. Okay. So I have a lot of questions on this. Again, I want to see the government's response, but right now I've got a lot of questions. And so as I had a point. So as a defense attorney, you would sit there going, I don't know what evidence they're bringing in, because so much of it has been suppressed. And if you are the defendants, you're sitting there going, okay, well, great. They can't bring in a lot of this. Fantastic. We are in a good position to go to trial because, again, when the government messes up, they have to bear the burden of it. You don't seize things properly and you're done. Okay. So the government gets a bunch of information suppressed. If I can understand now, because when you're looking at the amount of time the Chrisleys are facing and all of the counts against them, you're looking at this going, why don't you plead? Well, this brings a lot of information about it, because if you think that you're going to trial and most of the evidence that the government has gotten is fopped and it's been suppressed, then why would you plead? You're like, go ahead and try to prove your case. The evidence has been suppressed. Good luck with that. So for the court to then turn around and let it in is shocking. So we will see. All right. Rather than seeking to suppress the evidence for a second time, the Chrisleys sought to ensure that the government could not sneak in previously suppressed evidence without a hearing. If the government truly sought to introduce the evidence it derived from the warehouse searches under some exception to the fruit of the poisonous tree doctrine, we're going to keep calling it FOPT because it's funny. And it just brings me back to law school and it makes me feel like I'm young for a moment. We're going to forget that that's not true. As it stated in the pretrial conference, the Chrisleys asked the court to force the government to establish the admissibility of the previously suppressed evidence. Okay. The question this motion poses for the court was straightforward. Did the government have a valid legal basis to admit previously suppressed evidence? The government understood the issue perfectly, arguing that it did. It claimed that the evidence it sought to use at trial met two exceptions to the exclusionary rule. One, it came from an independent source, untainted love, untainted by the illegal searches. And two, the government would have inevitably discovered it. Would they? Or would they not? It also argued that the Chrisley's motion was akin to a motion to suppress and therefore untimely. It seems like the court might have agreed with that argument. At oral argument, however, the government quickly withdrew its timeliness argument. In the end, it asked the court for an evidentiary hearing so that it could perfect the record to establish an exception to the exclusionary rule. Yeah, because the appellate court's going to be like, bruh, what? Despite the government request, the court declined to hold an evidentiary hearing to reach the merits of the issue. This is going to go on for a while. So would it be fair to say the government fopped around and found out it might be? Oh, it might be. It might well be. Despite the government's request, the court declined to hold an evidentiary hearing and reach the merits of the issue. Look, here's where I stand on all of this because we're going to keep going with this. But look, if you are putting people in prison and taking their liberty, do it properly. You don't get to skirt the rules. Now, the government's going to have a response and be like, we didn't skirt the rules. The stuff from the IRS feels particularly egregious, but if the court already ruled it can't come in, you're stuck with it. At the end of the pretrial conference, the court declined the government's request for an evidentiary hearing to determine whether the disputed evidence could be admitted through an exception to the exclusionary rule. It is up in here. It's law school today. We've got the Constitution. We've got fruit of the poisonous tree. We've got exclusionary rules. We have warehouse searches. We have the IRS being like, oops, we didn't apply that payment to you. And in fact, we might owe you money. What? It later issued a ruling finding that certain emails were admissible because the Chrisley's motion was untimely. The court did not address the other categories of evidence the Chrisley specified in their pretrial motion. Instead, the following is the entirety of the court's order on the issue. Motion to require proof of admissibility is denied. After taking this matter under advisement, same as taking it under submission, at the pretrial conference, the court further reviewed the pleadings, R&R, and order on this issue and determined that the emails at issue here were previously allowed into evidence at trial pursuant to the court's denial of the defendant's motion to suppress search warrants for emails and electronically stored information. So they're seeing this completely differently. Thus, the motion currently before the court is untimely. The court is saying, no, the emails and the electronic search isn't included in the fruit of the poisonous tree. Oh, there's a lot to parse. I'm interested to see how the government responds. So the Chrisleys are arguing, look, it was all included, and the court's saying in this ruling, no, it's not. This is separate. So as a result, the court admitted much of the previously suppressed evidence and did so without requiring the government to prove that it had been obtained from an independent source or was otherwise admissible. Based on this court ruling and these defense arguments, I can absolutely see the court denying this again, and this also going up on appeal. All right. Argument. The court erred when it failed to enforce the suppression order. We've already seen that argument ahead of this, so we're going to keep moving. They're arguing the facts and the law together. The government failed to establish an exception to the exclusionary rule. It sounded like they wanted to, and the court was like, nah, we good. And the government's like, wait, can we make a better record? Because this is going to go up on appeal, especially when you have high-profile defendants or defendants that might have money. The chance of things going up on appeal is high, and I can see the government being like, can we just protect our case, please? Let us have a hearing, Your Honor. And the court's like, nah, we're good. We're good. All right, the government failed to establish an exception to the exclusionary rule. Yeah, it sounded like the court wouldn't let them. They go on to say, for example, as to the Google and AOL search warrants, the government must first establish that the affidavits establish probable cause independent to any information gained during the initial legal search of the warehouses. Here's what's interesting. When I did the podcast episode about these convictions, some of the things said in the emails were things I went, well, that's going to be very interesting to a jury. If those emails were kept out, I think this case would be a different thing too. So I understand why they're still fighting this, because those emails were things like, just find an accountant to make it work. So if you haven't watched the podcast episode on the Chrisley convictions, go back and look at those emails with the question in your mind about whether those emails might not have been admitted at trial if they were illegally gotten to. Now, would the government have found all the email addresses? I don't know. Probably, possibly. But the government has to establish, look, we saw these email addresses in the documents, but we also did a search over here and these emails came up because they used these email addresses to email an IRS agent or to communicate in other ways on other things. So, oh boy. Let's continue on. If the government meets this initial burden, then it must establish that it would have sought the warrants regardless of the initial legal searches. And that might happen, but it can't happen now. This burden requires more than mere conjecture or verbal assurances from government agents. They would have to show, look, especially when it goes to digital evidence, we found these email addresses through this that's completely separate from those other searches. And they might be able to do that. Let's see. The government must also The government what? Words. The government must also show that the lawful means which made discovery inevitable were being actively pursued prior to the occurrence of the illegal conduct. This second requirement is especially important. Any other rule would effectively eviscerate the exclusionary rule, right? Because it's like, no, seriously, we were going to do it. Isn't what you get to do. Applying these standards here, the government cannot meet its burden. The IRS criminal investigation began in earnest after its review of the financial records that DOR illegally obtained from the warehouses. So if they weren't being investigated before that, this might be an issue. The criminal investigation began because of the illegal searches. IRS Special Agent Arrow, S.A. Arrow. Wait, why are some of them officers and why are them special agents? I have questions. I'm going to have to look at the order of ranking at the IRS because I don't know it at all. But Special Agent Arrow was responsible. We've got Agent Carter and Agent Arrow. I don't know what's happening. Agent Arrow was responsible for opening the criminal investigation into the Chrisleys. His internal memorandum dated April 21st, 2017, stated that the investigation was predicated upon information received from the local news media as well as the Georgia Department of Revenue. Oh, boy. Well, there's that. The record further indicates that DOR had reviewed the documents and been in contact with S.A. Arrow prior to his opening of the investigation. Testimony cited. Further evidence that DOR's illegal warehouse searches prompted the IRS's criminal investigation can be more fully provided at an evidentiary hearing. The burden remains on the government, however, to show that its investigation was not prompted by the illegal search. The ESI search warrants were explicitly based on the illegally obtained evidence. On February 1st, 2018, a year after the warehouse searches, Arrow obtained a search warrant for documents the DOR obtained from the warehouses. Well, you can't search warrant the documents they already got. On February 7th, 2018, Arrow obtained and reviewed illegally searched materials from the DOR. On March 1st, 2019, Arrow obtained a search warrant for materials related to Todd and Julie Chrisley from Google and AOL. The AOL of it all cracks me up. Kevin Poole asked, are these fake names to protect their identity? Nope. No, they're not. No, they sure aren't, because they would have already testified in open court. And when it comes to government agents that testify, no, they're their names that they use. Because they've got to sign them onto the search warrants too. On May 24th, 2019, Arrow obtained another search warrant for materials related to the Chrisleys from Google. Arrow's affidavit supporting these search warrants states, quote, when reviewing the search warrant materials obtained through the Georgia Department of Revenue, investigators found cut and pasted 2014 bank statements in the name of Julie Chrisley and 7 Seas Productions. Investigators also obtained 2 requests for mortgage assistance that Todd Chrisley submitted to claim he had difficulty repaying the mortgages. The affidavit supporting the search warrant further admitted that the agents had not yet determined whether or not these cut and paste 2014 bank statements were ever sent to the financial institutions. Arrow admitted the search warrants for Google and AOL were sought only after his review of the warehouse documents and because of that review. They're laying out a very interesting argument, I've got to admit. In addition, S.A. Arrow admitted that his affidavit that, quote, I have learned that the Georgia Department of Revenue has had an investigation into the Chrisleys as a result of their failure to file state tax returns during the years that they potentially lived in the state of Georgia. In July 2017, Georgia DOR officials traveled to the Swanee River. Way down, damn it. The Swanee storage facility where they executed the levy and seized the subject items, the warehouse seizure. Yes, no, I'm not going to sing drove my Chevy to the levee, but the levee was dry. I'm really, really trying to rein in the ADHD at the moment to burst into spontaneous song. I should have just waited for that one. It was better than Swanee River. But you know, when we drove across the country to move to Tennessee, we did drive across the Swanee River. At one point, it had the lyrics of the song with the music and a giant sign. I was very excited. My kids were like, what is wrong with you? I'm like, anyway. All right. Pursuant to their agency's policy, the Georgia Department of Revenue officials inventoried the subject items. During the course of the inventory, the officials determined that there were a number of financial records within the subject items to include, but not limited to, boxes of the following types of financial records: bank records, mortgage documents, personal business, checkbooks, ledger books, receipt books, insurance records, records showing the Chrisleys and his wife's income, correspondence between Chrisley and his accountant covering 2006 to 2013, individual business tax returns. Additionally, the subject items included a number of electronic devices and storage mediums. As this lays out, S.A. Arrow admits in his affidavit that the primary source of information was the DOR seizure. I'm very curious what the government's going to say in response to that. In other words, the evidence shows that the unconstitutional search and what was found there influenced the government's decision to seek the search warrants. Under the FOPT doctrine, evidence later found in a subsequent search should be suppressed if the search was prompted by what investigators found in the prior unconstitutional search. Yup. An evidentiary hearing will likely provide even more evidence linking other aspects of the investigation of the Chrisleys to the initial unlawful search and seizure at the beginning of the case. Conclusion. We need a new trial. Thanks. Exhibit 1. Declaration of Bruce the accountant.
Let's see what Bruce has to say. Whoop, whoop.
Chad, I also need to know, well, I shouldn't ask. Do people still have AOL emails? Like, do AOL emails still work? Let's do it in a poll so you don't have to like out yourself as having an AOL email address. But can we do a poll? Does anyone still have an AOL email address and does it still work? So I need to know. Charlene, I also started with CompuServe. I remember CompuServe well and about. So we can go with, do you or anyone you know still has an AOL email address? And then the chat can let Beskin know what AOL is. Oh, AIM was my jam in law school. Like when AIM came around and we could message each other, like the professors didn't know what to do because the Socratic method, we're going to get back to this in a minute. The Socratic method works really well when you put somebody on the spot and then pepper them with questions, kind of like they do in Legally Blonde, and keep asking questions. But we had AIM. So your friends in class could just help you out if you needed it. So we could AIM each other so nobody really got put on the spot. I wonder how they deal with it now. Did they make you have your laptops closed? What's law school like in 2022? I imagine it's hard to do the Socratic method when everyone can communicate with each other. But anyway, I loved AOL. I loved AOL so much. And I was so proud when I moved over to Gmail. I was like, I got Gmail. All right, anyway, Bruce is a CPA. Let's see what Bruce has to say. I presently serve, I read this as proudly real quick, and I was like, that's odd to put in a declaration, but I was wrong. I presently serve as the accountant for Todd and Julie Chrisley. The Chrisleys have executed written and signed approvals for me to serve as their representative for conversations with the IRS, as that's why you have a CPA, so they can deal with the IRS, not you. Let's see. In this capacity, I have filed tax returns and made payments on their behalf. Also, as the Chrisleys' tax representative, I have spoken with the IRS and its employees about the Chrisleys' tax issues. While doing so, I was aware that IRS revenue officer responsible for handling the Chrisleys' tax issues is Betty Carter. After the Chrisleys' criminal trial, I attempted to ascertain what tax liabilities the IRS believed the Chrisleys owed, if any, for all tax years through 2020. This task was important to me because I was the accountant who worked with the Chrisleys to make payments in 2021 and early 2022 to extinguish their tax liability for 2014, 15, and 16. So when were these payments made? When these payments were made, or when those payments were made, I believe that they were equal to or greater than the amounts the Chrisleys owed at the time. So I was surprised when I learned that Officer Carter had testified at trial that the Chrisleys still owed taxes for those years. About 3 weeks after trial, on or about June 24th, I spoke to Officer Carter on the telephone. At the time, she told me that the Chrisleys' tax return for 2014 had been filed but not processed. Ma'am, this is going to federal trial where people are facing 30 years in prison per count. Ma'am. Filed but not processed. Wow. Yeah. Okay. This is Wendy's. What is happening? This was the first time she had ever informed me that the Chrisleys that there was a problem with the filing or processing of the tax returns. You're preparing for a federal trial involving taxes. And it doesn't say filed, not processed? Look, man, if a jury knew that, they wouldn't love it. You know why? Because people are so skeptical of the IRS. Okay. People are also skeptical of celebrities. I mean, to be totally fair. So when you've got to put one against the other, we've got a problem. You guys are like, pledge not donated, pledge not donated, filed not processed. Good God. Well, when was it filed? I guess is my question. When did they file it? How long has it been filed but not processed? Yikes. To follow up on this conversation and to seek clarification, I sent Officer Carter an email on June 27th asking what the fuck. No, that's not what it says. That's not what it said. That's not what it says. Jeanette said in the chat, this is giving off you have one job energy. I mean, yikes. So sent an email on June 27th asking about the status of the payments for the Chrisleys had made for the tax years 14, 15, and 16. On June 29th, Carter sent an email in response. In that email, she addressed another issue and then stated, please give me a call and I will explain. Please give me a call and I will explain 2014, 15, and 16. When I received this email, I immediately called Officer Carter. Oh, I bet that that's exactly right. On the call, she explained that the payments the Chrisleys had made had been received by the IRS but not applied to the balances for those years. When? I need to know when. When was that received? How long before trial was this received? I asked her to send me an email explaining the issue. I bet you did. But, ma'am, I'm going to need you to go ahead and put that in writing. I'm going to need this to not just be a phone call. We're going to need it. We're going to need you to put that in writing. What the fuck did you just say? The payments have been received, but not applied. Oh, man. Shortly thereafter, Officer Carter emailed me. In that email, she wrote, payments currently sitting under Mr. Chrisley's SSN are for $50,000 for the year 2014, $60,000 2015, and $592,000 for 2016. When I heard Officer Carter tell me this information on the telephone, and when I received this email from her confirming it, I understood that these payments she referenced were equal to or greater than the tax liability the Chrisleys owed at the time the payments were made. Put another way, when I spoke to her and read her email, I understood Officer Carter's statements about payments, quote unquote, sitting at the IRS to mean that the IRS had received the payments when they were made in 2021 and early 2022, and that the Chrisleys did not owe any tax liability for those tax years. Because I knew this information was different than what Officer Carter had said at the Chrisleys' criminal trial, I reviewed my records to confirm those payments, if properly credited, should have reduced the Chrisleys' tax liability to zero for each of those years. To ensure that I was correct about my calculations, I sent Officer Carter additional emails over the next few weeks to seek to talk to her about this matter. She finally agreed to speak with me on August 17th. Oh, I'm sure after she had words with her supervisor and the U.S. attorney. You have to talk to the attorney at this point. But she insisted that her supervisor be on the phone with us. Oh, I bet. Oh, I bet. I bet. I absolutely bet. It was a, oh, fuck. Oh, fuck. Oh, fuck. During the call, Officer Carter confirmed that the Chrisleys' tax liabilities for the years 2014 to 2015 were paid in full. As for 2016, Agent Carter said that she believed there remained a residual balance of approximately $3,000, but that this number was being checked for accuracy. That's a lot different than they hadn't paid, isn't it? Based on my knowledge of the Chrisleys' 2016 tax return and payments, such a balance likely reflects interest and penalties that the IRS replied after receiving but not processing the payments. Because it's just like the IRS to be like, oh yeah, we didn't apply it, now you owe penalties. And then you're going to have to fight with them over the penalties. But you have to pay the penalties while you fight over the penalties and then hope the government gives you your money back. The fucking hell. Okay. Emily, are you deeply skeptical of government agencies? You know. Oh, man. Let's hope there's emails attached. Let's keep going. Exhibit 2. Declaration of Terry Tiara. That's not what that says. Terry, I'm never going to be able to say the not Tiara now that my brain has read it the wrong way. Sorry, y'all. We're just going with Terry. Sorry, Terry Tiara. I apologize. We're dyslexic. It just, those letters have flipped and I'm not going to be able to flop them. My full name is Terry. I'm currently retired. I was previously employed by the IRS as a revenue officer. A revenue officer, oh, that would explain the difference between the special agent and the revenue officer, because I believe the special agents are the ones with guns and the revenue officers are just the revenue officers. A revenue officer is responsible for collecting delinquent taxes and returns, also to investigate and make determinations and assess personal responsibility for unpaid corporate employment taxes. Investigators to determine financial means, assets to pay delinquent taxes, and are conducted with taxpayers and or their representatives to reach resolution, determining the correct amount due, ensuring that payments and returns are properly processed. Yeah, processed, not just received, processed. And preparing adjustment requests to correct accounts is an essential aspect of the job. I have 34 years experience working in the collection division of the IRS. I worked as a field revenue officer for 12 years, supervisory officer overseeing field officers, officer and compromise specialist for 17 years. This person has a ton of experience doing things. Based on this experience and expertise, I'm aware that the IRS has multiple databases and computer systems that contain information about taxpayers. It seems that these systems might need a wee bit of an overhaul. Just perhaps. Just perhaps. I know you're adding like 80,000 plus new agents, but perhaps also some programmers to help fix the system. 2 of these systems utilized by the revenue officers are the Integrated Data Retrieval System, IDRS, and the IRS Integrated Collected System, ICS. IDRS contains tax data for all taxpayers, including individual corporations and others. This extensive database includes tax returns, taxpayer identification information, dates returns were filed, dates and amounts of tax payments made, including pending payments not posted to tax accounts, penalties and interest assessed, history of notices, and other communications sent to taxpayers. By the way, the IRS, they send it by the mail. Just FYI, they send it by the mail. And any and all current taxes due the IRS. ICS is the platform used by revenue officers to input, track, and maintain the actions they take with regard to a particular case. The 2 systems interface. As a revenue officer utilizing various command codes, they're having to do it by command line. Really? Really? We're command lining it? Oh boy, where's the room for error there? Shit. Okay. As an IRS RO, utilizing various command codes in accessing these systems would see all payments, both posted and pending, applied to all tax accounts. This would include payments applied under both spouses' social security numbers and jointly filed tax returns. The data obtained through access to both platforms would be ordinary and necessary data needed to fully research a taxpayer's tax status and ascertain taxes due. So this is going through how the systems work to support the fact that the IRS should have known. So this is all going to the agent would have seen it, and that's why it's perjury. Hopefully this is an email. I'm hoping this is an email. But I will say, when working for the courts, we had a bunch of command line programs and it was a shit show. And it's why the different counties depending on the state, the different counties couldn't interact. You couldn't figure out. It's like, how do these mistakes happen? It's because none of these systems interact. All of them are old. They needed command line inputs and they're a mess. And nobody had the time and the money to overhaul these massive databases because you need them to run things every single day. It is a problem. It is going to continue to be a problem. And I don't think it's going to get fixed until something catastrophic digitally happens. Improperly admitted evidence, and then they're going through the improperly admitted evidence, and this is the list of what they think is improperly admitted. Bank records, emails, and then other reports. I mean, I feel like a credit bureau report could have been pulled because they would have had their social security numbers. Like some of these might have been pulled, but the emails, maybe not. That's not even the end. That's not even the end of the documents. That's not it. But holy shit, that's a ride. The accountant is also making a motion for new trial, and the Chrisleys are making a motion for a judgment of acquittal, which is going to be similar to the motion for new trial, but they're saying essentially this is going to be, let's see, this is 26 pages. We're not going to get into all of it, but this is going to be, hey, the jury couldn't decide what they decided, so we're asking you to set aside the jury verdict and move for an acquittal. These are both common motions made. Let's go through their basic arguments, and then we're going to move on because I'm sure you guys have questions about other stuff, and we've been live for over 2 hours. So first, they're saying the government offered no evidence that Julie Chrisley participated in any of the specifically alleged bank funds or bank frauds alleged in counts 2 through 6. At trial, the government offered no evidence that she made any material misrepresentations to any of the listed banks as a part of any fraudulent scheme. It presented no evidence that she sent any communication to those banks at all, or that she intended to deprive any of those banks of their property. Because the trial records do not connect Ms. Chrisley to any of those banks, let alone to a fraudulent scheme involving them, no reasonable juror could convict her of bank fraud. As a result, the court should acquit her of the bank fraud charges, counts 2 through 6. Second, the government failed to meet, and this would have come up again at the close of evidence, and they would have made this, and this would have been denied, and it would have gone through or continued on. So this is asking the court to kind of overrule themselves, because at the close of evidence, and you saw this in the Depp Heard case, at the close of evidence, there's a motion to dismiss or a motion to acquit. And so this would have happened at the close of evidence. Obviously, it was denied because then it went into the defense case and then to conviction. But they're asking the court to reconsider it. Second, the government failed to meet its evidentiary burden to convict Todd or Julie Chrisley of the bank frauds alleged in counts 3, 5, and 6 because it failed to produce sufficient evidence that the alleged misrepresentations were material to the financial institutions. The government called no one associated with these banks as witnesses at trial, and it offered no testimony about lending practices in the industry sufficient to allow a reasonable juror to find beyond a reasonable doubt that the alleged misrepresentations were material to the transactions. Third, the government failed to offer sufficient evidence that Julie Chrisley committed wire fraud as alleged in count 7. Like its failure to prove 3 of its bank fraud counts, the government failed to prove that any of her alleged misrepresentations were material. It has to be material. The jury gets to determine what's material, though. So that's a factual determination. Fourth, the government failed to prove that the Chrisleys committed tax evasion as charged in count 9. The Chrisleys created The Chrisley's creation and use of 7C's production was lawful because Mr. Chrisley had no legal interest in 7C's income. The entity did not affect his tax liability, and its assets were not subject to any tax liens or other levies. Its creation is therefore not an affirmative act of tax evasion as a matter of law. In addition, the government presented no evidence that the Chrisleys provided false information to the IRS sufficient to constitute actual or attempted evasion. Fifth, no reasonable jury could find the Chrisleys conspired to defraud the United States as alleged in count 8. The government presented no evidence that Mr. Chrisley concealed income for the same reasons its allegations fail on count 9. In addition, the government's remaining arguments that the Chrisleys made false statements to third parties regarding their tax filings and filed incorrect and untimely individual or corporate tax returns do not establish a conspiracy to evade taxes. Because the government failed to meet its evidentiary burden, the court should enter judgment of acquittal for counts 2 through 9 for Julie Chrisley, counts 3, 5, 6, 8, and 9 for Todd Chrisley. So they're going to argue the law attached to the facts on this. And when we go into a deep dive, I can go into this a little bit more. I'm going to see if there's any other specific testimony that's pulled out in this, because again, this is a first look, but this is mostly, as we're scrolling, this is mostly case law at this point, saying this is why, this is the elements, there wasn't enough evidence. But again, this already would have been denied by the court once. I think the motion for new trial motion is probably going to be stronger in the eyes of the court, because again, they would have evaluated this already. Let's see if there's any other, I'm just looking for any other testimony that might pop out from this. It is, again, 26 pages with lots of law and facts saying, look, they didn't meet the burden, but the jury gets to determine the facts on the case, which is why those motions are difficult when it comes to a court. You have to find me not innocent. You have to find me not guilty as a matter of law. Those motions are much harder if they are not granted by the court at the close of evidence. And we actually saw that happen in the Kardashian Black China defamation case. We saw at the close of evidence, the court completely dismissed the causes of action against Kim Kardashian. And we're like, you didn't enter any statements that she said. So yeet. So sometimes they do work, but not always. Do you guys want to talk? We had a poll pending. So let's close that poll. And do you guys want to talk real quickly about the updates with the Chrisley civil lawsuit? Just pop a 1 in the chat if you want to hear about it real quick, and then we'll go to questions. I just want to know. Look, I just want to know if you want to know. If you want to know, we will do that for a moment. We'll do a quick update while I'm looking at the chat coming in here. Do you or anyone you know still have an AOL email address? No 65, yes 34. That's more than I suspected. It's about the portion of y'all with over 2,000 votes. It's about the portion of y'all that like popcorn flavored jelly beans. I wonder if there's a correlation. All of you are like, yes. Okay, chat, look. When we talk about the civil suit, here, I'm going to swoop as we get into the civil suit. We're just going to give a brief warning in the chat. Look. When we talk about the civil suit, it always becomes a mess with the other party involved in the civil suit. We are not going to besmirch, disparage, talk smack about the other individual in this civil suit. They are a creator on this platform. We're just going to talk about this lawsuit and what it is. I do not follow this creator closely. I don't want to. My life is better without it. I don't want to know. I don't want to know. So if anyone's going to ask, have you seen, this YouTuber do that? No, I haven't. We are booked and busy. We have other things to do, but we are going to talk about the lawsuit. And again, this YouTuber has 2 pending lawsuits, one with 7M, one going on with the Chrisleys. Both are defamation lawsuits. The Chrisley lawsuit was not the most robust lawsuit that we've ever seen, but there has been some recent motion in this lawsuit. It is still on calendar. It has not been dismissed, but part of it has been dismissed. So when we're getting into this, this was originally filed. Let's see. Let me pull up. We haven't talked about it in a while. The original complaint filed by Todd Chrisley for defamation against, what did he call her? A nondescript YouTuber was filed on, where is the date on this? I don't even see it. Is it down at the bottom? October 18th, 2021. So this has been going through discovery motions and things. Said YouTuber filed a counter complaint or a cross complaint, then suing some of Todd Chrisley's companies, but interestingly enough, not suing Todd Chrisley. So this came up for motions to dismiss. Todd Chrisley filed a motion to dismiss. I'm just going to show you the reply real quick. We have not gone through this too deeply. If we need to, we will. Y'all don't Beetlejuice it in the chat. I promise you, it's not what anybody wants. Especially me. What we don't love over here is social media mess. So this is Chrisley versus company and individual. And then where you get this extra little verses, you get company and individual then suing companies, 7C's Production, Courtside Group, and Live One Inc. So you get a counterclaim or a cross complaint where this company and individual are then suing Todd Chrisley's companies, but not naming Todd Chrisley or he would be down there. So this is, KJ's opposition to Chrisley's motion to dismiss confirms that said YouTuber has failed to plead viable claims for defamation, harassment, and IIED. So this is a motion to dismiss with regard to the counter complaint, these counterclaims. KJ makes no effort to distinguish controlling authority that dooms her counterclaims. The court should therefore dismiss, and it gets into the motion a little bit more. We're just going to skip to the answer in this. If you guys want more of a dive into this, we can get into what the countercomplaint is, but the thing is, it's already been dismissed, so it's kind of anticlimactic. There is still ongoing discovery issues in this case. Will that resolve? I don't know. There's been a stipulated dismissal for part of this, which is very interesting. So it says this matter having been resolved between defendants and third-party defendants, Courtside Group and Live One Out. So not 7C's, but this one, Courtside and Live One Inc. Those defendants are being dismissed. So the matter resolved between YouTuber and company on one hand, and the third-party defendants, Courtside Group Inc. and Live One on the other hand, it's hereby stipulated and agreed among all of those parties that this will be dismissed. So this has been dismissed as to these parties, but it has not been dismissed as to everyone at this point. So that's a final order in judgment. This pares the case down to just between them, but this does not answer the question about the motion to dismiss. So we will see if the motion to dismiss gets ruled on by the court, because some of the companies have been dismissed. So there are motions with regard to evidence. There are ongoing motions. There is a next court date, but the next court date isn't till June 2023. So there will be ongoing things with this case. It's not done yet. Could it end? Yes. Could it still resolve? Yes. The case has just pared down. It has not resolved. I've seen questions about whether it's resolved, but stuff came off calendar. We haven't seen a ruling on the motion to dismiss. That motion to dismiss still has to be, let's see. This motion to dismiss still has to be ruled on because it hasn't been yet. And I haven't seen anything on the record that indicates when that will happen. So if that gets ruled on, we will pull it up and take a look at it. But that's what's ongoing. That case is ongoing. It's going to be ongoing. There's discovery motions ongoing. I have not gotten into the newest updates in the 7M case. I will, if you guys are interested. I have not. So, Rochelle said, this is what I'm trying to figure out. Why not 7C? It seems, well, 7C is more directly tied to the Chrisleys. I don't know what these other companies are. I've not seen them referenced anywhere else. It could have been that the other companies, it's like these aren't actual existing entities, dismiss them out of the case. So, are Todd's lawyers different from the company itself? Let me see. The lawyers are likely the same lawyers for Todd and his company, because it would only make sense. It would be in the best interest of them to have one set of lawyers. And let me take a look at this last motion. It doesn't look like there's only 2 sets of lawyers that signed it. So there are lawyers. Oh, but these are lawyers for defendants, Courtside Group, and Live One Inc., which, let me see if those are different lawyers than the Chrisley lawyers. So, let's see. This is Robbins Kaplan for Todd Chrisley, and this is a different law firm. So the third-party defendants, Courtside Group and Live One Inc., had a different group of lawyers than Todd Chrisley and 7M have, or 7C have. There's too many sevens. So different group, which indicates to me that those companies are not, that part has resolved. The part with regard to Chrisley and his company has not resolved, and that will be ongoing. So with that is a quick update. So we will see. There is stuff that has happened in 7M. I will take a look at all of it and do a quick update in like a quick bit. I am way more interested, truthfully, in what's going to go on with these motions in the Chrisley criminal conviction, because there are some really big allegations going on in that criminal case. And there are problems there. There are problems there. I'm interested to see how the government responds. Normally I read through post-trial motion and it's like, yeah, you're doing the work you have to do. Those are the motions. On this, I'm like, oh shit, that's a problem. That's a problem. And with that, we should actually just FAQ around and find out, because we have lots of questions. I've got questions. You've got questions. We've all got questions. Let's just have some questions. Don't forget to put a question mark or a Q in the beginning of the question so I can see it and the mods can see it, so we can get into that. Nitro, exactly like this. Will you cover the 7M lawsuit? I covered the beginning of it. I covered the first filing. I have not kept up with it because we got very, very busy. And we will, if you guys want to get back into it, we'll get back into it a little bit. Will I be covering it filing to filing to filing? Probably not. Will I cover it in groups of filings if you're interested? Yes, I will. Autistic Shill says 7 is an unlucky number. I mean, those companies definitely have 7s in them. What's funny is 7 was one of my water polo numbers. 7 is I love the number 7. Question, why doesn't Judge Penny just schedule full days or several and just get the accounting done? I don't know. They still want to have, I think they want to have a full hearing. So if Judge Penny schedules it, it will probably go out to another court for a full evidentiary trial. I think Judge Penny probably hears other motions in the morning and then sets aside the afternoon for these. How and why she runs her courtroom the way she does, I don't know. I got another question about Morgan. Anything new in the Chrisley KJ? That's what we just did. Part of the defendants have been dismissed. I want to see what the court's ruling is on the motion to dismiss. I have not seen a ruling on that yet. I don't know when. There was a hearing. I don't know if the last hearing got set over. Let me just look at the docket real quick and I'll let you know. Here, I'll just pull up the docket again real quick and let you know, because the next hearing I saw was in June on the docket, but there should be a ruling at some point on these motions to dismiss, because they involve all of it. All right, let me look real quick and see on here. We'll just all do it together. Let's just all do it together. All right. Taken under advisement, and then the other things were dismissed. So this motion to dismiss is under submission or under advisement. So we should see it. There was a remote hearing on the 24th. No, I did not attend it, but that was taken under advisement. The other co-defendants are dismissed out, but that does not mean, let's see, 26 notice of filing of order of judgment. That's the dismissal of the other defendants. And then let me make sure there's no business addresses or otherwise on this. There aren't. The next, let me get to the section with the next dates on it. Hold on. Let's see. Upcoming hearings. Previous hearings. No, we got that. Let's see. Previous hearings, 824 motion hearing, 81 motion hearing. So this was a motion hearing held on the record for 824. That's under submission. So we should see a ruling on that at some point. And when we do, I'll go over, when we get a ruling on the motion to dismiss, I will go over what the motions argued and the court ruling just all together so we can do it all at once. The upcoming hearings, there's one on 9/13 that wasn't on calendar the last time I checked this, which is a motion hearing. Oh, no, because it was canceled. So I bet that was just related to the other one. So this is canceled. June 23rd, pretrial, 7/24 jury trial. Other things will pop onto calendar as need be. They set aside, let's see, what is that? 5-6 days for jury trial from 7/24 to 7/28/2023 for jury trial. So there will be a ruling on the motion to dismiss, and then we will update. We will just update all of it together. Hopefully that works, and we will. Let's see. Martha's like, I'm behind. Try college in the 80s. We didn't have, well, that's true. The 80s were tough. Question, will we get to see the James Spear deposition? Nope. Will we get to hear parts of it? Maybe. We might get to learn some of what was learned if it comes up into other motions, but no, at this point, that won't be public. Question, what's up with Olivia Wilde? I don't know. I saw that she did a Vanity Fair because this morning I was on Carson and Kennedy on Mix 104.1 in Boston. Love the crew at Mix 104.1. Love being on the radio in the morning. And we were talking a little bit about her getting served. This happened a while ago, but she just did a Vanity Fair, I believe. Could have been Variety. I confuse the two all the time. I know they're not even remotely the same. They both have V's. That's how my brain works. Apologies. But she just did, I think it was Vanity Fair, an article where she talked about how she felt being served when she was on stage, being served with papers regarding their ongoing child custody agreements with her and Jason Sudeikis, and not being thrilled with being served on stage, to paraphrase mildly. Jason Sudeikis came out and said, I don't know how the process server chose to serve her on stage. We've talked about that a little bit. The process servers make that determination. And what I don't understand in the whole thing is why Sudeikis' lawyer didn't just reach out to her lawyer and say, can we just serve you? And it's possible that her lawyer is like, good luck, go serve her. If you want to do what you want to do, because they were trying to move jurisdiction between two different locations, and jurisdiction was determined to be in California. So they were trying to move jurisdiction. Her lawyers might have said, good luck, go serve her. Godspeed with that. But process servers are relentless and will serve you where they can find you in public. And if, as a celebrity, that is in a public forum, that is where they are going to serve you. It happened to Shalene Johnson with the suit with the doctor that we talked about. She was at a meetup in New York. She had posted that she was going to be there on social, and the process server walked right in, right past everybody, and just served her. Especially if you are someone that is harder to get to, that is a public person, you can't just knock on the door and have Olivia Wilde like open the door and be like, you've been served. So trying to find them in public when they're not surrounded by security or otherwise is difficult. So I can understand they walked up and put them on stage. I can understand why a process server would choose to do that. I wish the lawyers would have said, hey, we'll just accept service. But sometimes it's like, good luck. Good luck finding them out in public. Best of wishes to you. And, you know, every time a process server has to go find you, it costs the other side money. So if people are getting petty, it's like, come find me, bro. And that might have been what happened too. So I don't know. But do I think they would have said to him, to Sudeikis, hey, we're going to go serve her on stage? No, I'm sure they were monitoring the process server that was hired by the lawyers, or just monitoring social media and like, they're going to be there this day. Great, here. That's how they find people, mostly by monitoring social media. And yeah, so I can understand why she would have been mad, but they have to give it to you. So Barry's asking, can they leave it at your front door on the mat? No, they have to give it to you. They have to hand it to you. When I was trying a case in downtown, we were trying a murder case and somebody was trying to serve the attorney I was with, and they chased us down the hallway in court and basically threw papers at her. And they're like, you've been served. And she's like, no, I haven't. Kept walking. And the papers laid on the floor. I was like, maybe we should go get those because like they probably have some of your personal information on it. Like, I don't know, your address. But tried to serve her in court because they knew where we were appearing in court every day. It was stressful. It was stressful. All right. True After Dark said, I'm here for the messy, Emily. I mean, this look, when we do first looks, it's because I enjoy you guys going on the journey with me. Not all legal filings are interesting. Some legal filings are very dry, but today gave. It was there's some there. I can't wait to y'all. I'm invested. I can't wait to see. Jennifer said she was probably dodging service. Could have been if she knew that that he was trying to serve her, she might have been being like, good luck. I don't want to deal with it. I don't want to deal with jurisdiction elsewhere. Good luck. But either way, it's not his decision. It's the process server's decision. And he doesn't know who his lawyers are hiring for service of process. It's like, I've hired you to do this. Just handle it. Anyway, so it could have been, or it could have been that she didn't know they were trying to serve her and didn't know this was going on. But obviously they knew custody stuff was going on. I imagine her lawyers would have had a head up. So let's see. Question, is acquittal or overturning a conviction automatically with prejudice? Z, this is a great question. A motion for new trial is exactly that. It grants a new trial. But if you are acquitted, if they change the judgment, which is very rare, that they're like, oh, there wasn't enough evidence for a jury to ever find this, that is double jeopardy attaching. So yes, it's with prejudice because you've been found to be not guilty. When a new trial is granted, you got to do it all again. So with a new trial, you got to do it all again. But if like in the Chrisley case, if the motion for new trial is granted, they're going to fight like hell on that suppressed evidence to try to keep all of that out. So, wow. Bex was like, yeah, it's a particularly sexy one. She was thick. There's like a lot of meat there. There's a little something. We love it. A little something to grab onto and have a conversation about. And we get to say fopped all the time. Fopped, fopped, fopped.
Fopped.
I've just entertained myself all the ways. Jen, did you know Starbucks charges more depending on how you order your drink? Example, sweet cream cold brew costs less than a cold brew with sweet cream. I kept track and asked WTF nicely. That's odd. I'm not surprised. I should go through the app and try to figure it out because that would be helpful. Teresa said, won't this be detrimental to the IRS if it's found that they didn't testify to the correct information? I mean, I think the public's opinion of the IRS is probably already a little bit low, but yes, that kind of an error is a problem. So, Rachel said SLED is currently searching a river by Alex Murdaugh's father's house relating to the murders of his wife and son. Crazy. I wonder if they're looking. I hate speculating when things are breaking in real time, but the first thing I thought when you were looking at a river, because in that kind of a case, bodies have already been recovered because they were there and his alibi was that he was at the father's house. I wonder if they are looking for weapons. I don't know if they recovered the weapons, and I wonder if that's what they're looking for. I know they just had a dust up, an evidentiary dust up in court, but weapons are my first thought when they are looking in water. The dust up in court, I'm going to do for the members only. I'll do a live reacts to it. But what happened in court on the Murdaugh case was really an evidentiary. They were fighting over turning over evidence with a protective order or not. And the attorneys were salty with each other. Salty. So Brenda said the executor claims $300 has to be held for a year in escrow in case someone excuse me, sues for being hurt on the property after it's been sold. I'm not sure what that's relating to, but thank you. Um, Joey said, what made you choose to be a legal analyst over being an attorney? I love that you did, but was curious. I caught you during the Depp trial and now a legal nerd. Thank you. I have a TED Talk talking about my experiences and picking something different. I had a lot of burnout. I had some health issues with regard to burnout, being a deputy district attorney. I loved what I did. But after my spinal fusion, I could not work in the same way that I was working anymore. I was not going to go the route of being a defense trial attorney. I went the route of working with online business owners, really, really loved it. But being ADHD and dyslexic, following up on client work was not my favorite part of it. Loved talking to clients and doing consulting, didn't love doing, contract writing and things like that. So during 2020, this is kind of the short, quick answer. During 2020, all of my clients immediately went, I don't know what's going to happen to my online business, my event planning business, my this and my that. And so I said, all right, let's stop what we're doing. I focused on my podcast. It started to grow, focused on YouTube covering the pop culture cases I saw happening because everything felt very divisive and crazy. And I'm like, let's just talk about Kanye West and the music industry and Toddy Westbrook getting sued. Can we just talk about something else, please? Anything else? Oh God, anything else? And when the YouTube channel started to grow, I was like, I enjoy doing this more and am very blessed to get to say, I enjoy doing this more. And I do. So I picked doing the things, that I enjoy the most. And I love it. And y'all being here, watching, liking, subscribing, joining me on, Patreon and the members and following me around the interwebs and shopping at the Law Nerd Shop help me to do that. I am also a less stressed version of myself. I have more time to take care of myself. I get to hire incredible people and support them in their businesses and their work. And it's great. So what do you reckon the legal fees has accumulated to? If this is relating to the Britney case, it's millions and millions and millions. Because my husband is so loud right now. I don't know if y'all can hear it, but I can. When we're talking about the Chrisleys, we're probably in the hundreds of thousands of range, if that helps. Autistic Shill said, I just want to say that my autistic daughter loves your calming voice. Her name is Steffi, short for Stephanie. Hi, Steffi. Thank you so much. People made fun of me about my voice in junior high and high school, and it took me a while to be comfortable doing a podcast because I got picked on about my voice, and I appreciate the compliment. Dave's Beats asks a great question with regard to the Chrisleys. What's the minimum federal time? There are no statutory minimums on this case. So in a case like Josh Duggar, you see a mandatory minimum where it says, if you do this thing, the minimum is this many years and the maximum is this many years. I feel like I'm completely not centered in my, there we go. We're professionals here. You get a minimum time of this and a maximum time of this. Not all cases are like that. Some cases it is, you get a fine up to this, sentence up to this, or both. And that can mean no time. That can mean probation. That can mean some time. And then there are ranges where the court gets to choose within the sentencing range. We haven't seen a sentencing range on this yet because we haven't even gotten to sentencing memorandums on this yet, but we will down the road. We're going to continue doing this. And I imagine even after the Chrisleys get sentenced, if this hasn't gone up on appeal yet, it will. There are some issues there. Are the Chrisleys in jail? No, they are on home detention, which again, home detention is something, if you can afford it, allows you to not be in jail because you're paying for the 24/7 monitoring. So they are on home detention. So, your voice is awesome. What could they say? Oh, the mean shit that kids say. Am I going to say all the mean shit kids used to say to me on the internet out loud? No, but it's amazing because people still hit it in the comments. I'm like, wow, I've been hearing people say that to me since I was in junior high. You would think that I would get over it by now, but occasionally you're still like, ouch, rude. But yes, no, made fun of all the time. And then eventually was like, who cares? I mean, people say all kinds of things. Steve Cass, is it time to look at our tax laws? I mean, the impact of lobbying on our tax laws is substantial. Our tax laws are deeply complex. I don't think they're set up for people to win. I think they're set up for some people to win. I think a more simplified tax code would benefit most? Would it benefit all? No. Do those who benefit the most take the most advantage? Yes, but you have to have enough money to benefit from our tax code. So I think there's a lot of room to have conversations around taxes. I hate that taxes are used as a political football because I feel like it's just used as a political football. And then you get, whoever's in power saying, oh, we can slide these things in for our people or our constituents or our area or this lobby group. And if I don't know, money is part of why our politics looks the way that it does. But if we changed the way our tax ran, then it wouldn't be doled out like treats to like, oh, thank you, good donors, good lobby groups. Here's your perks. But yet our tax code stays complex and keeps everybody on their toes, doesn't it? It's why I hate it when I see people trying to say, hey, blah, 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 you're gonna, this person didn't do this with their taxes and this person didn't do that with their taxes. It's like, let's take a look a little bit deeper because there are so many things that can happen. There are just so many things that can happen with regard to taxes. And I don't know. I always let that kind of stuff sort out until we get to is anyone actually prosecuting it? So, with that, let's see. I DM'd you to explain the wheelchair thing, but my handle here and on Insta are not the same. What's the best way? Email my please do. I will go look for it on Insta. I do get a lot of DMs. I will go look for it, but you can also email me and just put that in the subject line. My email is the Emily D. Baker at Semaphore. It's on Twitter and it's on Instagram. And it should be in the description box too. So absolutely email me. Joanna M. said, Chrisley talked about that, the finding of fact that he paid all 3 years long ago, about a year ago on his podcast. Well, then they should have known it when they testified to it. Thank you for talking about My Cousin Vinny. We watched it for the first time this weekend and thought it was a blast. Isn't it great? And you learn a lot about evidence. They do things really right in qualifying experts and stuff in My Cousin Vinny. Lisa asked, isn't this a version of the way Bill Cosby got released? I mean, the government doing things wrong in violation of the Constitution. Yes, different provision of the Constitution. And I did have an episode about Bill Cosby's release, because here's the thing that's so frustrating is watching when you're like, but when the government does it right, our system, or when the government does it wrong, our system would rather guilty people go free if the government fucks up than people stay in jail when the government has done it wrong. And that is the way our system leans. We rather have people who might have done the thing go free than have innocent people be in custody. And our system continues to get better at that. It has not always been good at it. It is not always good at it, but it is getting better at it. So, all right, let's see. We're going to keep going. I don't know why I can't keep messing with the arms of my chair. Lori asked questions. Are you going to follow the Danny Masterson trial? I'm going to look and see who's reporting on it to make sure we have reporting coming out of the courtroom that makes it easy to follow. And I will take a look. I truly have not decided yet. So Jordan said, everyone deserves to have the government make damn sure that they have a very good and very solid case if they're going to take away our freedom, even shitty people. Yup. That is our system was built on we don't like the way other systems do it, so we're going to do it this way. And they try. So let's see. We're going to continue on. Professor Chaos says, my first one in 96 was AOL and it still works. I wonder if mine would still work if I could even remember what my AOL handle was back in the 90s. Professor Chaos said, I don't trust a single federal prosecutor to respect Brady, as most have repeatedly violated and judges cover it up. The whole system is corrupt. I don't know if the whole system is corrupt, but there are definitely things that are done wrong. And the problem is you need to have an attorney that you can afford to pay to sort all of that out, and not everyone can. Money plays a big role in our system. Sin N, as of 1992, IRS agents are allowed to use pseudonyms. I had no idea. Hey, Lawn Lumber, good to see you. I'm going to use the phrase whenever someone asks a really dumb question. Your question has been filed but not processed. Seriously, WTF. Yeah, this motion for new trial is a WTF for sure. Totally remember needing an invite to Gmail. I do too. It made me feel special. I'm like, We love being invited places. Teresa B said CPA and they have an integrated system. LOL. I mean, not well. Vicky said, WTF, I work for the British version of the IRS, and all I can think is if this happened here, there would be consequences for the people involved. I bet there would be. I bet there would be. We will see what happens here for sure. Megan the Moon question, Natalie lawyer chick had to step away from YouTube for family stuff. I didn't know that. Sending love and light. I'm dying for updates on Darius Cook's case situation she covered. Is that something you would cover? I don't know if that is in court. I will look. I will reach out to her. I have not been on the internet a ton, so I have not seen because I have been sick. So I absolutely needed. I come in and do this. I prep my case, and I've been a little disconnected. But I will reach out to her and send her best wishes. It's hard, but again, Natalie has full-time life, full-time job, and this. There's no way I could do this consistently like this and work full-time. I could not. Do not have, well, I would drive myself into the ground, which I want to do. So could not do it with any semblance of balance. What do you think about the recent rulings about evidence in the Alec Murdaugh case? I think it makes sense that there are some protective orders in this case. It has to be. You have to protect the integrity of any prosecution, and that case is just messy. Question, would you cover the Rachel Williams versus Netflix because she's mad at Netflix for how she is portrayed in the Anna show and claiming defamation? I haven't even seen that, but I will. I covered the Queen's Gambit in Netflix. We need to peek back in what's going on with Carol Baskin and Netflix. Carol Baskin. We need to know. So yeah, I love a Netflix lawsuit. I think we just said this maybe with Danny Masterson. Question, how did The Princess Bride go down? My oldest loved it. Husband still hasn't seen it because he had an event with my youngest, which I didn't know. Shouting out the 666K Law Nerds. Hey, y'all can go ahead and subscribe and we can grow from here. River Shoal said, random, I'm here celebrating the fact that after months of back and forth, I was able to save an elderly woman's home from foreclosure. Happy dance.
Congratulations! It's a good feeling.
When you can fight the good fight, it is a good feeling. Let's see. Question, if AH is granted citizenship in Israel, what will that mean for her libel obligation and the outcome of her appeal? Well, the appeal can run no matter where she's a citizen. I mean, she's a defendant in court. The court already has jurisdiction. The appeal can run. I don't know if she's seeking citizenship in Israel. I don't know how Israel grants citizenship. So if she ends up becoming a citizen there, we will evaluate it at the time. It's a lot of what ifs, and it's going to depend if property's been attached here, if she's taken all property there. It will just depend. Donna, you missed my super chat in the beginning. I don't know if I did, but I will go look on the back end to try to find it because I don't still see it tagged here, but I will go look. Hempland, Texas said recovering from multiple surgeries, which has triggered a 3-day migraine so far. That is, recovering from surgery is hard. Migraines are the fucking worst. I'm so sorry. Listening to take my mind off of things. I mean, at least the IRS hasn't been like, we don't know you and lost your payment. Did I miss buying the box for Patreon? Well, MIA, no, you didn't. That's going to be released early in September. I got delayed because I was sick, and I will absolutely give everybody the heads up in adequate time to get those. Just like if we decide on a meet and greet while I'm in LA, I will give you guys a heads up. I don't personally like doing the, hey, this is coming tomorrow, unless I've like had an ADHD fever dream and like release new merch or something. But things that are limited, I try to give you guys a heads up. So that will be in early September. I want to make sure that people, if they want to join over on Patreon to have access to that they can do that at the beginning of the month if that works. And I want to give you guys a heads up. So I will give you a heads up on the date. It will be released to 3L Patreons first. And then if there are some more, there will be a period of time it will be released to them. I have it written in notes somewhere and don't remember off the top of my head what the team decided. Then if there are more, it will be released to the rest of the members. And then if there are some left, which I don't know if there will be, it will be released publicly. And then what I'm considering doing, since a lot of you wanted the cup, is doing a pre-order of just cups for those who want the cups and don't necessarily need the entire box. So that's what we are talking about and trying to figure out. So Yep. Aereo Scorpion said, I saw a guy on TikTok that accidentally got declared deceased by the IRS. Last I checked, he was a couple years into figuring it out. Holy shit, that would be a nightmare. And I could see it happen if your name is similar to someone else's name, or if your social security number is a few digits off. I could see that happening. I could see that happening for sure. Let's see. So, yeah, we will. Let's see. I'm going to get to a few more questions, and then we are going to get scooting off. Debbie, I will thank you. I will pass along the compliment to my parents and to my therapist, because it's been a group effort, and to my husband, because my husband and I have known each other for so long. He's been a huge part of me being the person I am today too. Especially when this stuff is hard, because there are days that working on the internet is hard. There are days when it is hard. There are days when covering these cases is hard. Days when covering these cases are just like, wow, that was heavy. Like tomorrow's podcast was just heavy. We get back into a bit more into the Kobe Bryant civil trial, and it's just sad. It's heavy. And some of the cases we cover are very heavy. They're heavy and hard to navigate. They're hard to navigate with compassion. People can be vitriolic on two sides. I mean, some of the comments, these aren't from law nerds. These are from people cruising by based on topic. Some of the shaming, body shaming, rage, like misogynistic rage towards Angelina Jolie is wild to see in the comments. I'm like, y'all cannot like her actions, but do y'all need to really be like, oh, well, women are crazy, blah, blah, blah. I'm like, that's not, have you been on this channel before? And some days it can be a lot to take in. So he's been really integral in that. And I really do try not, if comments aren't threatening or hateful, we don't just go through and delete comments, because I also think it's important to have a conversation and be like, oh, people either think like that or feel comfortable talking about that on the, wow, that's happening. Because I don't see that in my everyday life with the people that I talk to, but wow, there are those questions. It's wild. So it's just crazy. And it's really wild to see. And it's wild to see the vitriol still going on with regard to the Amber Heard Johnny Depp case. And while I've seen misogynistic comments towards Amber Heard, I have not seen the verdict as one of the reporters called it an orgy of misogyny. That's not what I saw. What I saw was a jury going, nope, that's not what happened. And so things get just so divisive and spun up. It's wild. Question, not a question. But Ethan Klein just tweeted he won 100% in his Triller lawsuit. I'm going to go to Twitter real quick. Was he granted, because the thing that was pending was attorney's fees. Let's go to Twitter and see what Ethan Klein tweeted out, and we'll just do it. Let's see, because that was under submission, and that's been under submission for a while. All right, let's pull up Twitter real quick and take a look. Let's see. Add to stream. There we go. Let's see. 19 minutes ago, just won 100% of our attorney's fees from Triller for their frivolous and malicious lawsuit. I doubt I will ever see a cent of that, though, because they seem to be on the verge of bankruptcy. Oh, dear. Hey, at Triller social media guy, DM me if you're looking for a new job. Oh, dear. Also, fuck you, Ryan Kavanaugh. I mean, and then the website that he took so much issue with, they still have a lawsuit pending. Our copyright and defamation lawsuits are still ongoing. We will have an update in September, hopefully, because they're the legal fees that were asked for were undoubtedly reasonable with regard to the Triller lawsuit that got yeeted on an anti-SLAPP motion. The SLAPP is still pending with regard to the Ryan Kavanaugh defamation suit. And I don't know what the judge in the federal suit is doing. The judge in the federal suit is like, we'll just see what's happening. So I'm not, Celine's like, Ethan is spicy today. Ethan is spicy every day. Ethan definitely engages in a different way on Twitter. I'm sure that Triller is pissed. I'm sure that Triller is pissed that they've lost the legal fees. Here's the thing that's hard though when you are Ethan. And yes, I'm sure Ethan has the money to handle it. It's still a giant pain in the ass to have to. But one of the things that now has to be dealt with is now you've won attorney's fees. Now you have to continue going after attorney's fees. Okay, while you're on Twitter, BitBoy tweeted a notice of dismissal yesterday. Did it finally get updated with the court? Wait, I'm going to go to the court website and pull it real quick. That was short-lived, the BitBoy crypto suit, and then I'll update that on social. Let me just go to Pacer real quick and see. Because I imagine they didn't settle. I imagine a Tuesday was like, no way. I would love to know why they decided that that was a terrible idea, other than that the lawsuit was a terrible idea. So let me pull this up real quick. This Q&A has turned into a research with me. And we are all here for it. Y'all know you can distract me. The mods are like, no, don't get her started on something new. But now we're just to answer all the questions. And since I won't be streaming Thursday because I'll be on a plane and it's a long weekend here in the US, we'll just do the things. Let's find BitBoy's ridiculous lawsuit. Because it's ridiculous. Let's see. That is not the right file number. Darn it. Where is it? I just need my file number. All right, we'll find it. I should probably just go to Twitter. It might be faster, but I know I have it saved here somewhere and we'll find it. Why didn't I just save it under BitBoy Crypto? That would have made more sense, but I didn't. Let's see. We need to get back to the Omni and a Hellcat suit too, because that was very interesting. Ben Armstrong. Let's just. Did I not save it? Did I really not do that? All right. Let me pull it up real quick. Sorry, y'all. Love you mods, but ADHD does what it does. It does. My birthday is on Labor Day this year. Yay for me. That's amazing. A happy Labor Day birthday. Let's pull this up real quick. Come here, case number. There we go. Oh, nope. That's not working. Damn it. We'll go to Twitter first. Is it just BitBoy Crypto on Twitter? Yes, it is. All right. Let's see. I'm looking on Twitter. There's a lot of other tweets. And I don't see. For people still. Oh, good. For filed today as promised. It's over officially. Okay. Here, let's pull this up. So he filed. That's what I really wanted to see. If it was filed with the court. For people still interested in this. People are interested. You sued another YouTuber. Notice of dismissal without prejudice. Bruh. It means you can still file it though. Just file it with prejudice so you can't file it again. Are you dismissed and closed? They might have filed it so they can file in a better jurisdiction because they filed in the wrong fucking jurisdiction. I don't know if that's over. If we don't see it refiled, but that's filed without prejudice, so they could refile. Yeah, I'm skeptical because why? Why would you file it? Is there any, I'll go do a little research and look for some videos. Is there any reason to file a lawsuit against another YouTuber? The world of the YouTubes are like, what the fuck are you doing? And your lawyer kind of said you're giving financial advice when it seems that you're not a licensed, financial advisor, and then turn around in a few days and just dismiss it. I don't understand. I truly don't understand that choice. I don't understand the thinking behind it. I don't understand dismissing it without prejudice. We know what that means. We know what it means. I don't know. I'm skeptical. I'm skeptical that it won't come back up. Rachel's like, just to scare another YouTuber. That YouTuber didn't take down their videos. So he didn't think it was public. then he didn't have a very good conversation with his lawyer when they said when we're filing it, it will be public. Because they had a Tuesday served. So let's see. Beth Cunningham has shared with Murdaugh there were 2 weapons. We know that there were 2 weapons. Died at the same time. Well, I mean, close in time, I think. I don't know if it was exact. Well, close in time. I don't know if it was to the minute. I don't think they can get that close. Shells found, weapons not found. I will keep looking through that for sure. ML Berg said, I found you through the Johnny Depp trial, going through a rough time. You were and are a lifesaver, whole family ADHD. Thank you. And that's what this community is for. It's not just me. Yes, I'm the one doing most of the talking. I like to talk. I'm the one doing most of the talking, but this community is the point. Janaea said, have you seen that Crumble sent out an email to their customer list updating the lawsuit saying that they have proof that Dirty Dough did steal their recipes? What? I didn't. Y'all are welcome. If you've got that email, you are welcome to tag me in it or hit my inbox because I did not see that. I'm not on Crumble's mailing list. I'll go look at social for that. Oh my. I'll be in Arizona this month. I'm absolutely going to DoorDash or Uber Eats myself some Dirty Dough cookies. I will keep you updated. Rachel Mills, because I know that Britney has court dates on October 26th and December 2nd. I will take a look. I've just seen the most recent, the December 7th one. That's what I'm very interested in. So I will take a look. Taylor, is the Bank of America Merrill Lynch lawsuit with Erica Jane or Erica Girardi real? I have a lot of questions about that lawsuit. It's why I haven't covered it yet. I need to see it shake out a little bit more. Just finished grad school last week, not law, but love watching your videos.
Congratulations. Yay.
Finishing school's a great feeling. Will we still get it if already signed up on Patreon but didn't get the box yet? It has not been released for sale yet. You guys will get the first crack at it. You will get the first information about it. When we have exclusives, they go to Patreon first. There are a few of you that are still upper tier on YouTube. You will also get notification about that, but there are different levels. When we moved things over to Patreon, part of the reason I did that a year ago, I think, almost a year ago, was to have more customer service control. And I have that on Patreon. Google, it's all through your Google account. There's nothing I can do. Good luck. So, question, are you doing a meet and greet in Arizona? I will not have time this trip. What I'm trying to do as I travel is tack on extra time to do it. So JC said, yeah, this is pretty on band for Brit Boy in my opinion, or for Bit Boy in my opinion. I was wondering about the without prejudice part. I am too. So with that, question, are you familiar with Rick Riordan's Percy Jackson series? Yes. The demigods have ADD and dyslexia as part of the lore. If so, who would your Greek godparent be? I have no idea. I have not really given it much thought. I'm going to have to ask my kid. My kid loved the Percy Jackson books. It's part of why we went to the Parthenon here in Nashville the first time we visited Nashville, because my kiddo was a huge fan of the Percy Jackson books and true to form hated the movie. But we wanted to go see where the movie was filmed. But yes, I loved that about the demigods. It's like, no, you're just not reading in the right language. I don't know. I would have to think about it. I am quite a water being, but also love archery. So we would have to think about it. With that, chat, this has been wonderful. We're at 3 hours and I have got to get going because I have to start to pack. I'm going to be traveling for a number of days for a very large legal convention. I will keep you in the loop with what I'm up to while I'm up to. There are some lawyers I am hoping to see while I am at this thing who are representative of or representing some of the cases that we've been covering. So I'm hoping to be like, hey, if you ever want to have a chit chat. So that I will be getting my continuing legal education. I will be able to see Saltz and Lonnie, Queen Levine, and others. So it is going to be a very interesting lawyerly thing. I hate that it's on Labor Day weekend. It is the time when it is, and there is not much I can do about that, which is a bummer. So with that, I will not be live on Thursday. I will be traveling. I will have a new podcast episode out for you tomorrow. I will be live again next Tuesday. That's not to say I might just not have an informal chitty chat live in case something happens, because I might. But I will keep you posted about that on social media. If you don't follow me, it's at the Emily D. Baker everywhere. But yes, I have to go do lawyerly things and educational lawyerly things. And it would be, we got to do it. So M says Emily's getting drunk and hearing gossip. I might not be getting drunk. Really, I probably won't be drinking too much just because we're still giving the gut a bit of a break. After it has been so dearly cranky with me. So sadly, probably not, but that's okay. I forget things anyway because ADHD. So I will be keeping track of the tea. I want to know so much more about this Chrisley case, y'all. We're not done. I have not seen this reported on anywhere. Oh, now I need to know, when was this filed? Like, I was going through the cases I've been covering and I'm like, there's a lot of info here. And I am surprised this has not been picked up more. 8/24, this was filed a minute ago. Y'all. Some very interesting allegations in that they're filing. I will talk to all of you soon. Thank you for being here. Thank you for being a law nerd. Thank you for doing the things. I'm at the Emily D. Baker all over the place. Yeah. Have a great and safe Labor Day weekend here in the United States. Everyone outside of the US, have a great weekend. Probably not a long weekend where you are, but it is a long weekend here. Hopefully you are able to relax and enjoy it. And it's fall, y'all. Enjoy your pumpkin spice everything. And I will see you next. Well, I'll see you tomorrow on the podcast and around social, and then I'll see you live here next Tuesday. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.